We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. I'm Judge Milkey, and together with me is Judge Kinder and Judge Sachs, and we are the panel for the 6 cases that we're hearing today. Our first case is Commonwealth v. Souther, 2019 P1254. The one thing I forgot to say in our introductory remarks is from time to time, you will see the 3 of us looking down or to the side. We are not checking the box scores. We have our case materials on our iPad and otherwise, and that is what we are doing. So with that, I will turn it over first to Attorney Moretti.
Good morning, panel members, and may it please the court. I'm Michelle Moretti for appellant Brian Souther, who is appealing 3 convictions of fentanyl distribution. The first issue concerns the admissible or inadmissible evidence of remote, irrelevant prior acts, or prior bad acts that occurred many months before the instant investigation even began. There was a motion in limine hearing that was held. The judge evaluated, among others, 2 issues. One, whether introduction of evidence regarding the Salisbury Police inception of an earlier investigation would be allowed. He would allow that for a limited introductory purpose, so the jury didn't think the case came out of nowhere. However, the instant case rises out of a very separate investigation beginning in mid-June from an entirely different police department who eventually began to work with the Salisbury Police Department, who engendered the earlier prior surveillance, which I
Ms. Moretti,
yes.
Ms. Moretti, can I ask you a preliminary question about the so-called prior bad act evidence? In most cases that we see involving prior bad acts, there is some, well, often criminal conduct. Here, what you're describing as other bad acts, in many respects, was simply observations of the defendant coming and going from a particular location or meeting with someone. Why should we consider that kind of evidence as prior bad act evidence?
Your Honor, you may consider that because the jury would have been permitted to draw a negative inference. The evidence concerned Mr. Souther's brief meetings with individuals where at times hand transactions occurred. Nothing was ever observed being exchanged. And there were additional traffic stops that Mr. Souther was subject to a search. And the jury heard a lot of incriminating evidence or potentially incriminating evidence. Yet he was never charged for these offenses. Those events did not even rise, with the exception of the traffic stop. The prior surveillance didn't even rise to the level of providing a reasonable suspicion. However, the jury could not help but infer that in the context of this particular trial, which was for drug distribution, that the other prior meetings were likewise drug distribution. And that would have wrongly suggested to the jury that the scheme prosecuted here beginning in November actually encompassed a far longer period. And that was incredibly prejudicial.
Counsel, how do you address the fact that the prosecutor seems to have gone out of his or her way to tell the jury, don't worry about anything that happened before November. This case is about what happened in November and afterwards.
Well, Your Honor, she said that, but saying so does not make it so. The Commonwealth went to incredible detail and trouble to admit the evidence of the prior surveillance. There had to be a reason for that. And I suggest that if you closely examine the prosecutor's language in closing, she uses rather a pejorative characterization of Mr. Souther's actions the previous summer. You can infer whatever you want about what Souther was up to. That insinuates criminal or untoward conduct.
Ms. Moretti, if the jury in fact drew an inference that those surveillance observations included criminal activity, hold that thought for just a moment and continue with your argument.
Yes. Well, in my brief, which the panel members have before them, I've detailed many instances where the prejudicial and often very irrelevant evidence occurred. So I will rest on the record as to that, but I will move to the fact that the evidence was prejudicial. It was far more prejudicial than probative, much more prejudicial than probative. It was not really relevant to the charges in November. It was highly—
Can I stop you again? I'm sorry.
Yes, yes.
If the jury thought that these were in fact other activities related to drug distribution, isn't there authority that suggests that that is relevant to the defendant's intent on the day of the deliveries? That is, an intent to distribute is an element of the crime.
That may be, in the first place, there was nothing that rose to the level of truly being able to accuse the defendant of making hand-to-hand transactions that were drug deliveries. He could have been delivering Red Sox tickets, giving directions, or greeting an old friend. However, the court would look at a temporal nexus. And I would concede that anything perhaps in November on the days of the controlled buys may be somewhat relevant, yet more prejudicial than probative, because again, nothing was seen. So the jury is left to infer a much larger pattern that is unjustified. The evidence as to the three transactions was not strong. The evidence of the November 30th transaction was the strongest. However, as to the November 17th and 23rd transactions, Souther was just merely present. I believe the jury could have found a reasonable doubt as to those charges, and here the evidence tipped the scale.
Let me just push back a little bit on the November 23rd. The defendant actually tried to give the officer the fentanyl in the cigarette pack, I believe. The officer says he wants another gram for $80. The defendant says, no, our shit's at home. But then Eaton produces another gram, hands it to the defendant, who hands it to the officer. How can, isn't that a pretty strong case for possession with intent to distribute, where he's actually handling it and passing it to the undercover officer?
Your Honor, under these circumstances, the jury could have found a reasonable doubt. The transactions were solely negotiated with Eaton. Many texts went between only Eaton and Souther. And perhaps technically, the passing, as the Commonwealth argued, could be considered distribution, but perhaps the jury could have found a reasonable doubt as to Souther's intent. So that was a close question. Any prejudicial evidence would have tipped the scale on that charge, Your Honor. If the court has no further questions, may I move on to some of the other arguments? The second I'm sorry, does the court have any questions?
Why don't you move on?
Thank you. The second argument concerns the testimony of the substitute chemist, Andrea Margarecci, who testified in place of the absent chemist, Brittany Walker. And it appears first, she testified as to hearsay detail when she specified the detail that UV and GCMS tests were performed. That is detail that counsel specifically objected to in the motion in limine. He objected to underlying data. That is underlying data. I was wrongly.
Do you agree that there was no description regarding the results of those tests?
No, there wasn't. But the fact that the analyst referred to those specific tests after she had described how they were performed would unfairly lead the jury to believe that the original chemist actually performed those tests. There is no evidence, though, that she performed all of them in that order. Some or all of the testing, one or more, could have been negative. So Margarecci could have simply found that the substances were fentanyl based on only one test, only one swab instead of two, or only a GCMS test instead of a UV and an MS test. That gave her testimony an imprimatur of reliability. This was test on the scale residue that was very scant and very presumably difficult to remove to test. Therefore,
just to be clear, are you saying that the testimony that the following tests were performed, and my opinion is that it's fentanyl, is an implicit statement that one or more of those tests was positive for fentanyl?
Yes, yes.
Okay.
Yes, that is what I'm saying. She may testify as to her independent observation, but the detail surrounding the tests and everything that implies is what the hearsay objection is to. And defense counsel specifically objected. He had no need to object again, Commonwealth versus Brady. Furthermore, he objected that the testimony was completely in violation of Souther's confrontation rights because he had no opportunity to cross-examine either of the chemists regarding the delicate specific underlying procedures that would be required to remove faint scale residue upon which this result relied and which the Commonwealth relied on to show that the conduct was associated with a pattern of distribution. It was a negative inference.
So the Commonwealth points to a question left open in the Jones case about whether evidence concerning collection of swabs could be admitted through the testimony of a person who may lack personal knowledge of the specific examination, but who's familiar with the general procedures and protocols ordinarily employed at a given facility in connection with such an examination. So if Margarecci had been able to testify, well, this is our usual procedure for swabbing items that have traces of some powder on them in order to get a sample that we can test, then some effective cross-examination could have been done, it seems to me, at least some, but there was no effort to examine her about that, either by the Commonwealth or the defense, to say, well, you've testified about your practice for doing swabs. Is this the general lab practice?
Well, Your Honor, the defendant bears no burden to elicit that testimony. He was concerned about opening the door. It was the Commonwealth's burden to prove that this was fentanyl in a proper way.
But when you're talking about confrontation and inability to effectively cross-examine, why would it not have been effective cross-examination to say, okay, Ms. Margarecci, you've testified about your practice for swabbing, but do you have any knowledge that this is a general lab practice, one that the other chemist would have followed? Walker.
I suggest that he wouldn't, that wouldn't be beneficial to him. He complained that he could not cross-examine either analyst about Walker's fundamental underlying techniques. And she even though there were lab protocols in place, the substitute analyst could have mishandled the evidence. There could have been fraud. There could have been a misjudgment. It has been known to happen in the Commonwealth before, Your Honor. And that is why the evidence was unduly prejudicial. And I see my time is running out. The meatiest issue is at the end, the testimonial nature of the photographs introduced in lieu of testimony. I would simply say that those photographs in lieu of physical evidence were accusatory documents prepared by the police, offered to prove an essential element of the Commonwealth's case, and contemplated as proof, made as proof to prosecute a criminal in a trial, and therefore they were testimonial. It doesn't quite fit because it's a photograph. Even if the court were to analyze under an authentication analysis, the photographs were not authenticated by Margaret Ritchie, who never testified that they represented fairly what she had had in her presence. And I see my time has expired.
Let me see if either of my colleagues has any follow-up questions. Hearing none, thank you very much. We will hear from the Commonwealth.
Good morning, and may it please the court, David O'Sullivan for the Commonwealth. Unless the court has a preference otherwise, I would track the order that my sister used and first address the issue of whether the judge abused his discretion in admitting certain surveillance observations made by the Salisbury police in the pre-November investigation surrounding the condominium that is 1B Sandpiper Way in the condominium complex and the particular truck and the defendant. And I would submit that he did not abuse his discretion to find that these were relevant. And I'd make a few observations about these observations that were admitted. And there were 4 that were admitted by the Commonwealth. First of all of them served to connect the defendant to the particular condominium, which was an issue in the case because that condominium had significance because drugs were later found there, in addition to a weapon with which the defendant was actually charged. He wasn't charged with any quantities of drugs that were found in that condominium, but he was charged with the weapon. Second, it connected, all these observations connected him to the particular truck from which the controlled buys were made. Now, do these—
Mr. O'Sullivan, can I interject a question here? I understand your point regarding the probative value of the connection to the condominium and the truck, but were those really contested issues at trial?
Well, what was contested issue at trial was the defendant's involvement and his intent to be a participant in these drug transactions. And the Commonwealth submitted, and I think it's true that it tends to establish his connection to that enterprise if he is connected to the truck and if he's connected to the condominium where the drugs were ultimately found. Does it directly establish those propositions? No, but it's a link in the chain of proof. Now, if the defendant's theory was he was simply a ride along, it tends to refute that if it, in fact, this was a truck that was associated with the defendant and not necessarily Eaton, or equally associated with the defendant as it was Eaton. And same with respect to the condominium. And the other point with respect to these observations, and I would quibble with the characterization of them as prior bad acts, were it a prior bad act to occupy a condominium, I would be engaging in a prior bad act as we speak, nor is it a prior bad act to be associated with a particular truck. Now,
a juror certainly could draw a negative inference from the fact that the police were conducting surveillance of a target over a course of several months.
Absolutely, thank you. And this is an important point. I would like to first contest that the issue of the mere fact of surveillance being a prejudicial thing that shouldn't have been admitted at trial is not a preserved claim. there is a difference between objecting in limine, as the defendant did quite comprehensively with respect to prior bad acts. And I would agree with my sister that counsel's motion was quite comprehensive with respect to prior bad acts. But there's a difference between a prior bad act and a surveillance observation. A surveillance observation may show something that's not a prior bad act, but rather has relevance, broadly speaking, in the case, but not itself constitute an inherently prior bad act. Specifically here on the June 1 observation and the September 6 observation only connected the defendant to the condominium and or truck. They solely had that function. Those are surveillance observations. They are not fairly characterized as prior bad acts. So I'd submit that to the extent that is raised for the first time on appeal, it should be reviewed under substantial risk standard. And there's no case that I could find standing for the proposition that the mere fact of knowledge that the defendant was under surveillance was itself so prejudicial as to require reversal on a substantial risk standard, where there wasn't more information about the nature of activity that was under surveillance, why they were under surveillance. As the court's aware, we can sometimes admit hearsay testimony to counteract any misimpression that might be created on the evidence that a particular, person was singled out arbitrarily by law enforcement. We can sometimes admit that sort of information. None of that was admitted here. The Commonwealth didn't seek to admit the reason why focus was on the defendant, on the condominium, and on the truck. None of that came out. It was simply, did you receive information that caused you to begin surveillance? But I would agree. Yes.
Speaking about the motion in limine, it objected to the use of prior bad acts generally, but then mentioned 3 observations specifically. The defendant's brief goes beyond those 3 to talk about other instances of surveillance. Are those properly preserved?
Well, I would say that counsel was quite comprehensive in his motion in limine in saying, including these, I believe there were 4 that were enumerated there, including but not limited to these. I believe there was similar language in there. So I would submit that prior bad acts were preserved issues, but the issue of surveillance was not a preserved one.
Although there was never a general ruling on that motion that I could see. There was a ruling as to the 2 specific acts that the prosecutor said she intended to pursue. The others she withdrew, but there was no general grant or denial of the motion insofar as it was not limited to the 4 specified items. Is that fair?
Right. I think that's fair, Your Honor. And so it was incumbent upon the defendant to object in the moment, if it were not enumerated and ruled on ahead of time explicitly. But I believe the defendant did preserve most, if not all, of these claims. It's just that they're not good claims. And now, with respect to those prior bad acts, there was one in which a hand-to-hand exchange was observed. And I would make a few observations about that. First of all, the judge made a pretrial ruling that given the lack of follow-up in the investigation, you won't be allowed to characterize that as a hand-to-hand transaction or a hand-to-hand drug transaction. And the testimony was clearly prepared. The prosecutor clearly prepared these officers, and there was no such testimony. It was merely, you can testify to what you observed, and which would here was a hand-to-hand exchange that occurred immediately after he left the condominium. And again, I'm sorry, this is on the August 30th incident. The hand-to-hand exchange occurred immediately after he left 1B Sandpiper Way and occurred at the rear of the truck with an unknown man on a bicycle. Now, do I think that was the most helpful in evidence for the Commonwealth? No. Do I think it was particularly prejudicial to the defendant? No. It's the function of cross-examination to bring up competing inferences to those argued by the prosecution. And the defendant elicited that, well, you don't know exactly what was exchanged. There was no follow-up, and you couldn't see what was exchanged. You don't know whether it was a drug transaction. All of that came out on cross-examination. So I don't think that was particularly prejudicial to the defendant, even if the court were to find that it was an abuse of discretion to admit it. But as Justice Kinder noted in his questions to my sister, there is case law suggesting that prior instances of distribution, to the extent the evidence supported an inference that this was one, are relevant to a defendant's intent with respect to drugs. And so I would submit that the judge did not abuse his discretion. And yes, Your Honor.
Counsel, unless my two colleagues have follow-up questions on this point, it might be a good time to turn to the substitute witness issue.
Sure, and there are two aspects, obviously, to the Griner rule. The first says that, of course, a substitute examiner may testify in lieu of the actual forensic analyst, but we have to abide by two rules in Massachusetts. The first, of course, is that you can't testify on direct examination to the specifics of the hearsay on which you relied.
Right. So I come back to the question: isn't stating that the two tests were performed, I forget, the GCMS test and the other test, and then she opines that this is fentanyl, an implicit statement that the file shows that there were positive results to one or more of those tests?
Right, and that's fair, but it's also within the limits of our rule, Your Honor. I mean, in the same way, if a defendant were, if there were a substitute medical examiner who were to testify on the basis of a toxicology finding that the defendant died from an overdose, and a substitute examiner were to testify, as my opinion, on the basis of this a toxicology report that he did so, the implied finding was that the person, the non-testifying person who did the toxicology report, that what the results of that were was that he died of a fentanyl overdose. That is still within our rule to do so, as long as the toxicology, or in this case, the UV and GCMS tests were stuff on which an expert would normally rely. And so
you in your brief cite the Bazanowicz case, saying that it's permissible to identify the hearsay material on which the substitute expert relied. But Bazanowicz also says the expert can't testify to the details of the hearsay.
Correct.
So
right.
is talking about going inside the file and seeing that the GCMS and UV tests were performed, is that the hearsay material on which the Margarecci relied, or isn't that more like the details of the hearsay?
Well, I would say we would draw the line between the nature of a test that was given, what was the test, and the results of that test. And I think that's a line that's supported by all the language that's cited in the Commonwealth's brief in our various cases that set out the parameters of what can be testified to on direct examination. The tests that were performed at this particular lab, again, Margarecki had particular knowledge about, because she was a supervising chemist, not only generally in this lab, and she reviewed the lab protocols and revised them, but also with respect to in this individual case. So it was already out in testimony and permissively which 3 tests were used at this particular lab in the direct.
But not on this particular material.
Not necessarily on this particular material. That's true. And so in direct testimony, it was disclosed what particular tests were used. But I would submit that is not, that it is within our rule as long as the results weren't.
What's the best case other than Bazanowicz for saying that the precise tests that were performed can be testified to by the substitute expert?
Well, we cite Bazanowicz, but we also cite other cases that talk about Grady, for example, talks about a substitute analyst may testify to his or her own opinion, but not on direct examination to the original analyst's test results. And Rivera, the 2013 case of the SGP, while not permitted to testify to the underlying factual findings of an autopsy he did not perform, a substitute examiner may nevertheless base his opinion on those factual findings. So I think those cases also draw a line between what information, what hearsay information you relied on, i.e. what test, versus the result. And
Counsel,
even
to
if-
what,
yeah.
to what extent are you relying, if at all, on the fact that the substitute chemist here was the direct supervisor of the absent chemist?
I think that is definitely, something that takes this outside the circumstance of Jones, which is relied on by my sister in the principal brief, and arguably may raise an issue that was reserved in Jones. Margarita could definitely speak to the evidence protocols, to the collection protocols in this particular lab. In
But
fact,
she didn't speak to the swabbing protocols, did she? She just talked about how she did it, not about how the lab generally did it.
correct,
The
and it
Commonwealth
was
didn't elicit that latter evidence.
correct, and it was the defendant's option on cross-examination whether to elicit that, and a difficult choice to make in determining whether they would open the door to underlying hearsay.
Since your time is getting short, can I ask you about whether this, assuming hypothetically that we determined it was error, whether it was harmless beyond a reasonable doubt? The first of the three transactions based on which defendant was convicted, as I understand it, was a November 17th transaction where, as far as the evidence shows, he was just a passenger in the truck. He didn't say anything. He didn't pass the fentanyl. So that's the particular, if you were to view them in isolation, that seems to be the weakest one. Could not the testimony that the scale residue was positive for fentanyl have helped tip the jury, the balance for the jury, at least on that offense?
Thank you, Your Honor. Any influence that the scale testimony could have had on the November 17th transaction would, I'd submit, pale in comparison to the November 15th one, where the defendant is touting the strength of the drug, saying the fentanyl is strong and good. The November 23rd, where he engaged in passing the fentanyl, and the November 30th, which he conducted alone, and then in particularly vivid testimony, thanked the defendant, thanked the Officer Tremblay for his business. So I'd submit that to the extent there was any sort of prejudicial effect on that, it would pale in comparison to the other properly admitted evidence, which is not challenged.
Okay, unless my colleagues have follow-up questions? Seeing none, thank you both live.
We are live and on the record.
Thank you very much. Our next case of the morning is Commonwealth versus Pratt, 2020 P 479. I just want to remind the parties that we have read the briefs and the record, so we are familiar both with the underlying facts and the arguments of both sides. So since 15 minutes is generally not a great deal of time, we would urge you to, as they say, cut to the chase. We will begin this morning with Mr. Hartquist.
Thank you very much, Your Honor. For the record, my name is Richard Hartquist and respectfully arguing on behalf of Scott Pratt. Your Honor, the defense would frame the question that's before the court today as whether Mr. Pratt is permanently subject to being stopped, interrogated, searched, and ultimately arrested whenever he puts his car on the road. The idea that he was traveling to a drug source city and from a drug source city, Your Honor, is not really a credible component of whether reasonable suspicion or probable cause has been developed. The case of Commonwealth versus Webster, Commonwealth versus Cordero, Your Honor, I was reading Webster earlier, is one that I lean on fairly heavily in my brief, because that ultimately says that travel to or from a drug source city can never be a factor in considering whether we have reasonable suspicion or probable cause. And by redacto ad absurdum, Your Honor, the question is whether all Keene, New Hampshire residents with prior convictions are subject to interrogation, search, and arrest because they're on our roads. Realistically speaking,
Counsel, can I just interrupt?
Of course.
Are you saying that it cannot be used as a factor, or that it either alone or with not much else does not add up to probable cause? Because those are two different things.
I'd respectfully say that it can't be used as a factor. Quote from Cordero, travel from a drug source city cannot in any way be regarded as suspicious. So I would argue, Your Honor, and even in considering the totality of the circumstances, I'd respectfully argue there's not enough here, but that should not be a factor in the court's calculus, Your Honor. I've analyzed this case in a couple different manners, but I think the easiest way to present it to this panel is to think about it in phases. The officer initially spots the defendant's vehicle and simply sees a New Hampshire license plate. That results in a query. Now, he follows the defendant for some way and realizes that he's traveling exactly 65 miles an hour. He's traveling safely. He just happens to be traveling north on 495, which is headed towards Lawrence. If he was headed south on 495, Your Honor, he'd be headed towards Lowell. And eventually, at some point, he'd be headed west. He'd be headed towards Holyoke or Springfield. So that is what I would respectfully argue is why Cordero says it can't be viewed as suspicious. And of course, Cordero references the fact that there are an awful lot of law-abiding citizens traveling between these destinations, Your Honor. So if we look at a New Hampshire license plate and extrapolate to an automobile stop, search, interrogation, and arrest, it's just going far and fast. And it doesn't abide by the strictures of the Constitution, Your Honor. The officers knew that Mr. Pratt had a valid license, that they knew that his vehicle was properly registered. They even observed him on his way heading north to determine that he probably was the gentleman who owned and registered the vehicle. He was operating fine. The officer doesn't follow him to Lawrence, and it's probably relevant that the officers actually, prior to the stop, never know he's even in Lawrence. They pull him over after following him for 2.5 miles, looking for a CMVI to justify the stop. The officer openly admitted at the motion hearing that he had a hunch. He pulled the defendant over. He asked for a license and registration. The stopping sequence was safe and immediate. He pulled the vehicle over fine. The officer did not at any time suspect the use of alcohol or drugs. And the gentleman presented a license and registration. Now, here's where the Commonwealth will say, well, he was real nervous. And of course, the courts have repeatedly said that interaction with legal officials can make individuals nervous. I'd add to that fact that prior to even making the stop, prior to the vehicle even heading southbound on 495 towards Keene, the officer had already called backup. Now, backup for a CMVI is uncommon. Backup for when we intend to search, interrogate, and arrest someone is a little bit more common. At that point, he didn't even believe there was a second person in the vehicle. So he was calling for backup to deal with one individual.
Okay, counsel, let's assume that there's lots of evidence that the reason he wanted to stop the defendant's car was to investigate his hunch of drug possession. Since he still observed a lane infraction in person, doesn't even under Buckley, he have the right to stop him, at least to process that violation?
He does, Your Honor. And there is some uncertainty surrounding the idea of the vehicle having slightly crossed the fog line briefly, but assuming arguendo that that's the case, then again, we have the time-honored scope of the detention must comport with the reason for the stop. We have a stop for a CMVI, yet we immediately have questioning, and the questioning was designed specifically to elicit answers from the defendant that would incriminate him. That's when Miranda has to be given. So yes, we have him over on the side of the road justifiably, as this is a state that acknowledges that a civil motor vehicle infraction stop is allowed. So he pulls over for that civil, and it's allowed regardless of what the true motivation of the police officer is. Now, I do argue in my briefly that it runs afoul of the Equal Protection Clause because of the fact that he's just randomly stopped, well, not randomly, but he's stopping everybody from the Keene, New Hampshire area. While they're not a protected class per se, it is not constitutional or equal protection to specifically target people from that certain area. So he pulls him over, and assuming the right to make the stop, he escalates the encounter. He keeps the license and registration. He doesn't return them after checking to the defendant. Now, the defendant's not free to leave because he has his license and registration. The officer also states quite clearly that he never intended to let this defendant leave. He was going to complete his investigation one way or the other. Now, the defendant's nervous. I cite numerous cases that say nervousness is not enough. We have the defendant coming from a drug source city, not enough. We have a prior conviction, not enough. and we have evasive answers. Now, the evasive answers were generated prior to Miranda, and the defendant has a right to not tell the police officer anything if he so chooses. So it doesn't seem that that can add to, even if we're considering in a totality of circumstances idea, it doesn't add to an.
Counsel, and to the extent you're relying on Cordero, wasn't it significant in Cordero the timing of the stop and how long it was extended? I did not, tell me if I'm wrong, but I did not see anything in the transcript here that says anything about how long this stop lasted.
The police officer testifies, and I cited in my brief, that the interrogation lasted for a significant period of time. So I'd argue, and I believe the Commonwealth objected to me including that citation because I drew it from the grand jury minutes. But the timing of this, even if we just read the content, we understand that there's questioning at the window. We understand that the defendant is taken out of the vehicle, he's searched, and it's relevant that both the defendant and the passenger had no noteworthy contraband on their persons, no significant amounts of cash. They were searched personally and nothing was borne out. They were both then removed to separate cruisers. And I would remind the court that Mr. Pratt was taken, searched, and questioned at the rear of the vehicle for a significant period of time, then placed in handcuffs in the cruiser. The Commonwealth wants to argue that wasn't an arrest because the police officer said the words, "You're not under arrest." But if that's not an arrest, I'm not certain that anything besides being put into a jail cell and told you're under arrest is an arrest, because the defendant was clearly not free to leave and he had submitted to the authority of the police officers.
Mr. Hartquist, you have raised a number of different arguments. If we were to conclude that the exit order in this case was not justified, is that alone dispositive of the case?
Yes, absolutely. Because after the exit order is the search. You need reasonable suspicion for an exit order and you need probable cause for a search. But the three reasons that we often cite as justifiable reasons for an exit order were not present. The officers, again, and I respect the candor of the officers. They openly admitted they did not fear for their safety at any time. The defendant did not engage in any furtive movements when he was being pulled over. The officers didn't have independent probable cause for an arrest. In other words, they hadn't seen a drug transaction. They didn't have any information from informants or anything like that that would give them probable cause for an arrest. So the only argument that the Commonwealth can possibly approach is that there was reasonable suspicion to conduct further inquiry based on the factors previously cited: nervousness, evasive answers, traveling near or toward a drug source city, and a prior conviction. But as I opened, Mr. Pratt doesn't permanently forfeit all his constitutional rights for having been arrested 5 or 6 years prior to this stop. It's a CMVI, and the scope of the stop has to be equal to the scope of the inquiry. The inquiry here, the officer, again, admits openly, he was trying to figure out how he could get incriminating information from the defendant in furtherance of his hunch that somebody coming from Keene and heading on 495 northbound is up to no good, is looking for drugs or buying weapons or doing something illegal, because Lawrence is a city that has a particularly high crime rate. But that's been rejected on too many levels and in too many cases. And I cite in my brief after Cordero, this court addressed Commonwealth versus Bowen and Commonwealth versus Harris. And while it's possible, I'd argue respectfully, to distinguish any two cases, there's always a tiny detail. And I would argue that the timing that we were just discussing is a very small detail and perhaps an irrelevant detail. Some officers very quickly get to the interrogation, very quickly make the exit order. But whether he makes an interrogation prior to Miranda without justification, or he makes an exit order without justification quickly or slowly, is not necessarily relevant to the analysis here. In Cordero, the police cited the exact same 4 factors. Now, police officers in our state are trained to write reports in a certain way. And the reason those 2 reports look similar is because the police officers are following protocols. And as a result, we have a case that's not distinguishable because the police are describing them and couching their description in the same terms. So while Cordero may have been longer, and I'd argue respectfully that it wasn't longer because we know that the defendant in this case was pulled out first and questioned and locked up. Subsequently, the passenger was pulled out, handcuffed, locked up, that the search was extensive. Every container in the vehicle was searched. They searched the center console. So,
Counsel, can I interrupt?
of course.
In response to Judge Kinder's question, you seem to say that, or at least suggest that we should look at the exit order first. After the exit order, they searched the vehicle. They either did have probable cause or did not at that point. They didn't seem to learn anything from the exit order other than the fact that there were no drugs or weapons found on the two men. Why wouldn't it make sense to actually cut to the chase and get to the search, that there was no probable cause for the search?
Well, absolutely not probable cause for the search. And the district attorney is going to argue that there was a pipe that was found in the center console. And I suspect that that's going to be central to that argument, if I may presume to anticipate. But we have a pipe that the police officers suggest is equally usable and legal for marijuana use. So even if that pipe comes out of the vehicle, it doesn't create probable cause for an additional search. Now, obviously, we have the issue where the motion judge specifically ruled that he did not find the officers credible and that they could see the pipe exposed from between the seat and the center console. So that makes the pipe irrelevant in every way. Now, according to my argument, if there's no reasonable suspicion for an exit order, then obviously there can't be probable cause for a search when, as Your Honor astutely noticed, they didn't find any new information from the time they took him out of the vehicle and locked him in the police cruiser. But the officer on the passenger side does try to claim that he saw this pipe. Well, it's not relevant because the judge didn't credit it, and it's even less relevant because a pipe for smoking marijuana is legal. In addition, there's been an argument in the district attorney's brief that, well, the officers didn't smell marijuana. Well, the officers also didn't report smelling crack cocaine or crystal meth. There were no drug odors, and nobody in the vehicle was suspicious or suspected of being under the influence of drugs or alcohol or any kind of narcotics. So really the pipe's completely irrelevant, and Your Honor's observation that nothing was learned between the time that he was asked to exit. And as I look at this at every step, if we can justify the CMVI stop, everything after that, beginning with the questioning, moving on to the exit order, moving to the arrest, and moving to the search, it's illegal at every level. Again, this is not a case where the police observed a transaction or had information from an informant that something was afoot. This is a case where the officer openly admitted he had a hunch that because this gentleman was from Keene and he was driving in a perfectly legal manner up 495 North headed to Lawrence, that he was engaged in criminal activity. And those parameters would literally lead to almost everybody being subject to searches, exits, and arrests. And that's what Cordero stands for, and that's what its progeny backs. We can't just randomly go out and start searching and arresting people on a hunch.
Counsel, your time is about to expire. Let me ask you one more question or two.
Of course.
Your client, I take it, is still incarcerated?
He is, Your Honor.
And he's incarcerated only on this conviction?
He is, Your Honor.
Okay. Unless my colleagues have any follow-up questions, we will hear from the Commonwealth.
Thank you for your patience.
May it please the court. My name is Chi Lee, Assistant District Attorney for Middlesex on behalf of the Commonwealth. The motion judge committed clear error when he, without explanation, discredited two troopers' consistent and uncontested testimony about a glass pipe protruding from a bag wedged between the passenger seat and center console.
So counsel, what is it that, as a matter of law, required the judge to credit the testimony of the officers? It surely can't be that the testimony was uncontradicted by affirmative evidence, is it?
No, Your Honor, there are 2 points. One is this court has the ability to review credibility assessment. Although this court gives deference to judges' factual findings and credibility assessment, it is not a rule of blind deference.
And for that, you rely on a single appeals court case from 40 years ago in a civil case?
in Springate, where this court reviewed and actually rejected a trial judge's credibility assessment in a civil action. And if you look at Medina SJC's case last year, where they rejected a Superior Court judge's credibility assessment, where she, in a prefatory statement, say anything not in her order is discredited. The court rejected that broad credibility analysis and found that it was improper. And the second point is, if you draw analogy from
Mr. Lee, may I just interrupt you for a second to let our panel chief know that
I am here.
Right.
I came back.
Yeah, and I did want to ask about the credibility judgments. I mean, if the judge had said, because of fact A and fact B and fact C, I don't find the officers credible in their observation of the crack pipe. And we thought that fact A, B, and C were all clearly erroneous, or his findings of those facts are clearly erroneous, then I can see you might have a hook for us to say, all right, then his credibility judgment based on those specific findings was also clearly erroneous, or at least invalid in some sense. But where he just says, I don't believe them, the implication being that it's based on demeanor evidence, particularly where he was asked to clarify and did not, what hook do we have to second guess that?
And I think that's the point of Commonwealth's position, where the judge did not explain the reason why, with two troopers testifying to the same fact, where the judge seemingly looks like the judge credited everything but that one specific fact.
Is there any case that obligates the judge to explain why he didn't credit particular testimony?
No, but I would encourage this court to follow Convey v. Medina, where the SJC reminded the judges that you cannot just discredit everything without an explanation. In Medina,
counsel, I'm still here, by the way. I have no idea why the camera's not picking me up. I think you're overreading Medina in terms of what the court was saying there. I think the court was very unhappy with the judge just issuing a blanket rule that anything he or she did not explicitly credit, she discredited, and that's very different from taking a credibility finding where the judge could not have been more explicit that he or she did not credit, the testimony, that we can overturn that.
Sure, Your Honor. There's another point. If this court can look at motion for new trial cases, for example, like Common v. Lies 481 Mass 1, the 2018 case from the SJC, where the court reiterated that motion judges are not required to accept affidavits, but at the same time, they require judges to explain the reason why a motion judge accept or reject affidavit. You can use that analogy here. And as Justice Milkey pointed out in Common v. Karen K. This court's opinion last month, this acceptance or credibility assessment is a principle that goes to the resolution of disputed subsidiary facts. Here, there are no dispute whatsoever. And a very important part of Commonwealth's position is there was no explanation, despite a Commonwealth attempt to get an explanation why.
Where does your assertion that the judge has a duty to say why he didn't believe the officers? I don't see any cite for that proposition.
Correct. There's no case law in the Commonwealth, or actually even in the country, to suggest that the judge must make that finding. However, I would suggest that Medina is pointing out to the motion judges or to the trial court judges that it is best practice to provide some justification or reasonings, especially in this case where both officers testified to one fact that's not been cross-examined on. And when the motion judge in this case credited the pipe was a cracked pipe, and that was the focus of cross-examination, this credibility assessment under entire record does not make sense. And without a justification or explanation why, the Commonwealth have a hard time to accept this credibility assessment. And if you look at the finding itself, the judge specifically found the bag was open and not sealed, but there was no testimony whatsoever about whether the bag was open or sealed.
Mr. Lee, Isn't it common practice across the Commonwealth for judges in motion hearings to say, I credit the testimony of X witness in its entirety and say no more and simply make factual findings thereafter?
Yes.
So it's not what Judge Liu here did is not an uncommon practice at all.
The uncommon part is when the judge made a specific finding on one specific fact without explanation, and that's.
Did he make a finding or did he just decline to credit the testimony? He didn't find there was no crack pipe there, did he? He just said, I don't credit the officer's testimony that there was. So I see that Medina says a judge can't make findings inconsistent with the uncontradicted testimony where there's no evidence to support those findings. But I don't see the judge making an affirmative finding here.
The Commonwealth's position is when a judge just using the phrase I disbelieve or I discredit without explanation, the judge could use that as a tool to avoid any kind of review, as what happened in Medina, where the judge just used in a prefatory statement that I disbelieve anything not in my order.
Counsel, why do I think we should probably move on. In terms of if the judge's finding, if you will, that the Commonwealth did not prove that the crack pipe was in plain view before they started the search, how was there a probable cause here for the search?
There's another key point before I move on to that question. I'd like to again address that when there was no finding about whether the bag was open or sealed. So the judge made an inference about the pipe protruding from the bag. And that's the only way you can have a draw an inference that the bag was open or sealed, because there was no direct testimony about whether the bag was open or sealed. So if you look at that angle, the factual finding is actually inconsistent or contradicting to his own finding. On the one hand, he discredited the pipe was protruding. On the other hand, he said the bag was open and not sealed. And the judge also did not make a finding whether the passenger made a swipe movement, which is very crucial to the Commonwealth argument about a probable cause. And if this court were to find that there was no pipe and there was no furtive movement, the Commonwealth acknowledged there was no probable cause for the officers to search the vehicle. However,
the defendant had already been ordered out of the car by the time this alleged swiping motion occurred. Is that correct?
That's correct, Your Honor.
All right.
But just
sorry, go ahead.
Yes,
did I hear you correctly? You said that if the Commonwealth does not overturn the finding with regard to the pipe, then it acknowledges it has no probable cause for the search of the car.
That's correct, Your Honor. Although this case is better than Cordero, where in my brief, I explained the difference between leaving in the drugstore city and heading towards the drugstore city at 1:30 and provide undeniably false statements to the officer. But in this case, better than Cordero does not mean there was probable cause. And without a pipe, the Commonwealth acknowledged there was no probable cause. However, the key point is the judge did make a clear error when this court had the ability, although limited, to review credibility assessment. This court in Springate pointed out it was not a forbidden territory. And specifically in Springate, this court reviewed one side, the plaintiff's side, where there was one single witness. On the defense side, there were 7 witnesses where the judge discredited it. This court reviewed the entire record and found that it was improper. This court should do the same in this case, where there was uncontradicted testimony offered by more than one officer when there was no explanation for that specific decision, despite the Commonwealth request for one. And there was a judge's factual finding that's inconsistent about whether the bag was open or not when there was still direct evidence to show that. This court should find that there was clear error and include the pipe in the analysis of probable cause in this case.
So we can make a finding, you're arguing, that the pipe was in plain view and that the pipe and the other factors amounted to probable cause. Is that your argument?
Yes, Your Honor. So the logic goes, if this court were find that the credibility assessment was an error, then that statement has then become credible. At that point, this court can use that to supplement any findings that the judge made. And if you look at the entire record, the judge made inconsistent findings about the bag itself. and about the swipe movement about an officer's, another testimony about viewing the pipe in plain view. If you look at the entire record, you should have a firm conviction that an error was made in this case.
Okay, and let's go back to the exit order. At the point that the defendant was ordered out of the car, it's uncontested that officer or trooper O'Keefe was not aware of any crack pipe
Correct.
in the car. What established reasonable suspicion as necessary to get the defendant out of the car?
One point about the pipe is if you do find that it was an error not to include the pipe, through the collective knowledge doctrine, you could review the pipe in the analysis of reasonable suspicion for the exit order. At that point, the officer knew that the defendant had traveled at 1:30 to a drugstore city for his hometown and come back 1 hour later with another person in the car. He was extremely nervous. His lips were shaking, his hands were shivering, and he also undeniably lied about his whereabouts earlier in the day, and he has drug offenses. When you combine all these facts together, especially the visibility of the pipe itself, there was reasonable suspicion to issue an exit order. This case.
Okay, is there any? I've read the transcript, and I don't recall any testimony from the other trooper that the pipe was found prior to the exit orders.
So there was no direct testimony about that, but if you look at the transcript itself, Trooper Lapulato testified the first thing when he arrived to the passenger side is he observed the pipe itself. You can look at it at page 65 of the transcript. And if you look at Trooper O'Keefe's testimony is when Trooper Lapulato arrived, he was confronting the defendant about his lies of his whereabouts. At that moment, he was not out of the car. So you can make the inference that when Trooper Lapulato observed the pipe, Trooper O'Keefe could use that information. When reviewing that question, you can use that information to review the order.
So if I have you correct, you're asking us both to make a finding that the pipe was lying in plain view and draw an inference as an appellate court as to when the trooper saw the pipe in plain view.
Yes, Your Honor.
Okay, and anything else you would like to say?
No further questions from the panel.
Oh, I don't have a question, but just something that might be good to keep in mind. We have not decided this case. We will decide this case sometime around 1 o'clock today. And then I think it's fair to say we will get our decision, however it comes out reasonably quickly. Hypothetically, were we to rule in the defendant's favor, one could anticipate a motion to expedite the rescript. Understanding that possibility, it might be a good time for the Commonwealth to run up the flagpole whether or not it would intend to seek further appellate review under that hypothetical situation.
Yes, Your Honor, and before my time expires, I'd like to briefly point out the scope of the conditional plea, where the defendant in his brief raised several issues that's not specifically reserved in the conditional plea. One day after the Commonwealth filed its brief in this case, the SJC issued an opinion in Gustachi. In that case, the court had an opportunity to review whether a claim is not reserved in the conditional plea, is not reserved in conditional plea, whether the court can review that claim. The SJC in that case did not review that claim directly. All they did is talking about it's a claim not raised in the motion to suppress. It's a different situation in this case. This court should hold the defendant to the terms of the conditional plea where it was not specifically reserved in that.
I'm confused. I thought what was reserved here was that the motion to suppress was erroneously denied. What argument is he making on appeal that you claim was not reserved in the conditional plea agreement?
So my time has expired. May I please respond?
You may answer the question.
Yes, Your Honor. In the conditional plea, there are 3 claims to be reserved. One is the stop. My apologies. One is the statements to the police. Second is the exit order. The third is the search of the vehicle. So the stop and the scope of the stop and probable cause to arrest, they were all outside the scope of the conditional plea. And if you look at the federal case law where, for example, Commonwealth v. Anderson, the 10th Circuit case I cited in my brief, the court found that in the motion to suppress, when the ground for the motion to suppress is not specifically reserved in the conditional plea, the court should dismiss that claim. And where in Gomez, the SJC followed the federal circuit, followed the federal practice, this court should follow the same thing, where a claim is not specifically reserved in a conditional plea, which is what happened in this case.
Okay, counsel, I think we understand it. So unless my colleagues have any further this on YouTube.
You're live.
Thank you very much. Thank you very much. We are here for the 3rd case of the morning. It is Commonwealth versus Hickman, 2020 P 837. I want to remind counsel that we have read the briefs and therefore are familiar with both the facts and the basic arguments. So I urge you to cut to the chase. And obviously, I would remind everyone not to use any names that could identify the victim in this case. And with that, I will turn it over to Mr. Benyon.
Thank you. May it please the court, I represent Mr. Hickman. The first issue is a sufficiency of the evidence argument. The government was required to prove a touching, which it simply failed to do in this case. Mainly the evidence focused around the DNA evidence from the underwear. And I just want to go through a couple of points. First of all, there was other DNA taken from the underwear that didn't match my client. It really wasn't pursued, but the government's own expert stated that there was a potential of 4 other people to come in contact with the underwear. With respect to the sperm cells, and I want to make this is my main point, is that the alleged victim in this case was found on the marital bed. And this was an argument that trial counsel continually brought up. And it was the defense's theory that that's where the DNA came from. It was a transmission from the bed to the underwear. One point that could lead to that conclusion is the fact that with respect to the sperm count, this is found on pages 181 to 182 of volume 3. Usually you would expect a large number of cells in the ejaculate. Here, it was simply just greater than 50 cells. And that could show that this just was transmitted from the, as I said, the marital bed. One of the problems with the government's case is that, and as I know you're familiar with the facts, so the 2 women come into the bedroom. My client is by the bed. The alleged victim is on the bed. And then the mother tells the child to get dressed. It takes a few minutes, presumably more than 1 article of clothing was put on, but we don't know where the underwear was with respect to the child. So for example, it seems too likely, and I think everybody just presumes that it was on the bed. And I think that it was, but without knowing where the underwear was in relation to the child or the bed, it's very difficult for the government to prove their case, especially with respect to the DNA. This is a very circumstantial case. Very circumstantial. I'm not really sure why. Well, I'll move along. There was one part of the testimony which I just want to highlight, and that is Mrs. Salem. She said she was trying to explain, and this is portions 29 and 30 of my brief. She was trying to explain why she took the cutting where she did from the underwear, and she discussed the idea of drainage. Again, this is not, the testimony wasn't that the defendant ejaculated on the alleged victim, and then it drained, and she took the cutting from there. She was just only trying to explain why she usually takes a cutting from that portion of the underwear. And again, in this case, a low sperm count really doesn't seem to satisfy the idea that the defendant ejaculated on her. Remember, the element that the government failed to prove in this case was a touching. There had to be a touching. This is not a case where the government meets its burden by showing that, for example, he ejaculated on the underwear and that the girl put them on. That doesn't suffice. In this case, there has to be a touching. This was specifically dictated by the trial court's ruling. So with that, I'll answer any questions that you might have with respect to the first argument, if there are any. If not, I'm happy to move on.
I think we understand the argument, counsel.
All right, so one of the other reasons why this was such a weak case with respect to the touching is because the victim never really did, in her interviews later, talk about or allege that the defendant did anything. So for example, if on volume 3, page 4 through 5, this is, I believe, the judge just kind of explaining what the testimony was.
What the interviews showed?
Yeah, the interview. And so,
yeah. So can I ask some preliminary questions about the nature?
Sure, go ahead.
Yes. Are those SAIN sane interviews, or were those SANE sexual assault nurse examiner conducting the interviews, or both? And does the record tell us?
The record seems a little convoluted. The transcript says SANE, and that's what my client is going off of, and why I'm raising this argument that my client wishes to put forward. The argument is two parts, right? So I think the first thing that this court needs to do is just read the transcript, and I think based on what we all understand, the difference between
obviously the reason I'm asking is because of your 803.4 argument about that the content of the interview was made, or the statements in the interview were made for the purposes of medical diagnosis and treatment.
I understand that completely.
If there's no evidence that the person conducting the interview was doing so for the purpose of medical diagnosis and treatment, then that argument kind of falters or goes away. So it's important to know.
Yes and no. So let me just answer your question. So your job is, first of all, obviously, to read the transcript. And I think from the context of the evidence, you'll be able to make a determination as to whether which sane interview this was, SAIN or SANE. Again, my client is going off of the transcript, but if this court were to disagree with that, if it were to conclude that the transcriber merely erred, then you would, in your opinion, cite the context and the reasons why which type of a sane interview you believe it is. But whether it's a SAIN interview or an SANE interview, my client's main position that he has discussed with me extensively is that those parts of the interview should have been brought out, whether it was through
this is the parts that said she'd never seen anybody else's privates and no one else had seen hers except her mother and the doctor.
That's right.
Okay,
that's right.
So I want to make sure I understand. You talk about making arguments in the alternative in your brief, so I want to understand what the two of them are. One is, as I understand it, that her statements were made for purposes of medical diagnosis and treatment, and therefore should have been admissible under 803.4 for the truth of the matter asserted, and that either, I suppose that counsel was ineffective for not advancing that argument, or that there's a substantial risk analysis.
For not raising it, yes, and there is a substantial risk. However, if you were to find that this is an SAIN interview, then the judge did say that he would allow it in under the state police of state of knowledge,
right.
Which was never brought up again. And so in that instance, again, my client feels that it was ineffective for counsel to not bring it up.
Okay, so how can we resolve that? I mean, it's clear that the judge said, I'm going to give you some time to think about this.
Yes.
Whether you want to get the evidence in through calling the police officer, and I would give a limiting instruction about it's for the state of police knowledge, not for the truth.
Right.
I think that's at least implicit in what he
Yes.
says about that. And the defendant evidently, or defense counsel, presumably in consultation with the defendant, thinks about it overnight, and in the morning, without any discussion of on the record, they move directly to closings, and the judge says to the jury, we're not going to hear any more evidence, and the defense rests. So isn't it manifest that the defense counsel thought this through carefully, and whether it was a reasonable judgment or not, had some reason for not calling the officer, and therefore we can't resolve this ineffective assistance claim on direct appeal. We need an affidavit.
That may be one direction that you go through. However, I guess I would say this, looking at the close nature of this case, and with these kind of cases, what always can be difficult is because of the sensitive nature of the evidence, a jury could be steered towards, instead of finding guilt beyond a reasonable doubt, finding guilt just out of an overabundance of caution seems to be the standard that I sometimes think I see. While you can say that an affidavit and a motion for new trial would be a better way to go on this case, where you have those statements from the young girl in the whatever type of sane interview it is, not brought up, that is a violation of the defendant's right to present his defense in a substantial
Well,
way.
if the judge allowed defense counsel to do it, but defense counsel chose not to, it seems to me that wouldn't be a violation of the right to present a defense. It might present an ineffective assistance claim, but I don't see
Point
precluding
taken.
the defendant from presenting evidence in support of his defense.
Point taken. Again, my client feels that it was ineffective for defense counsel not to raise these in some form, whether it's an SANE or SAIN. Again, where the judge granted or said that he would allow it under the police knowledge exception, to not bring it up was ineffective. That's my client's, I think, main point there.
But your client, as I understand it, could have called the victim to testify and presumably thought that through and decided that would be a mistake.
That seems to be the way the record shows. Yes, there was discussion. And I think for logical reasons, both sides seemed hesitant to call the victim.
Can we, the statements that you think should have come in one way or another are that she'd never seen anyone else's private, and that no one else had seen hers except a doctor and her mother. How would those statements be made for the purposes of medical diagnosis and treatment? Let's assume that this wasn't a sexual assault nurse examiner.
Let's assume that it was a sexual assault.
Let's assume that it was. Even if it
okay.
was a nurse examiner, how would those statements about whether she had ever seen anyone's private have been made for the purpose of medical diagnosis?
In that case, so oftentimes nurses will ask kind of how the why they're there, what caused the need for medical attention, and so it usually it works to a defendant's detriment, where the narrative to the nurse kind of discusses the assault and what took place. Here, this type of narrative shows that she certainly didn't engage in any indecent behavior with Mr. Hickman. And I think that's what his point is that if the victim herself says that nothing occurred, how can you not bring that in under the defense, especially where the case was so circumstantial? There's just no evidence of a touching whatsoever in this case. None whatsoever.
Wouldn't it have been fairly plain to the jury that the evidence turned entirely on the DNA? And that the Commonwealth had no evidence that a touching with the defendant's penis occurred?
No,
Or else it would have brought it in.
we don't know. That's the whole point. We don't know. And so it could have been and you've got 12 different people who come in with their different life experiences. It's difficult and a little unfair for you to ask me what the jury as a body would have thought. I don't know, but you know, the trouble with this case is because the evidence doesn't really tell anything that what the two women saw, what the mother testified to. It does allow the jury's mind to just kind of run wild a little bit as to what occurred. That's always going to be to the detriment of the defendant, especially where, even though it wasn't a lot of DNA, but some DNA was found on the underwear. The question is there a reasonable explanation as to how the DNA got there? And in this case, there is. And even though the defense counsel did a good job pointing that out to the jury, once again, in these types of cases, your job is to make sure that the jury found beyond a reasonable doubt that a touching did occur. I'm not sure how you do that in this case, but beyond a reasonable doubt is supposed to be a fairly high threshold, and the only entity that really sets how high that threshold is the reviewing court. Initially the jury, but then the reviewing court. If it's going to be a low standard, then cases like this are usually affirmed. But a higher standard where the government must show a touching, and again, the government could have charged with any other things to hold the defendant accountable in this case. But in this case, they said they would prove an actual touching, which they did not do.
Okay, counsel, unless my colleagues have follow-up questions, your time has expired. And
Thank you.
Seeing none, thank you very much. We'll hear from Ms. Lee.
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. I'll go in the same order as my brother and start with the sufficiency of the evidence. And I agree, this is a circumstantial case. In the defendant's brief, he suggests that the premise of two equal but inconsistent inferences renders the Commonwealth's case insufficient. And here, the evidence, though circumstantial, is quite compelling. The external genital swab of the victim had sperm fraction on it, and that male DNA was sufficient to exclude 99.92% of the population other than the defendant. I'm sorry, the male population. And her underwear had seminal fluid and sperm cells on it, and that those seminal fluid and sperm cells were found on the interior crotch panel of the underwear where the vagina drains. The swabs taken from other parts, the samples taken from other parts of the underwear showed that there was no sperm or swabs on the other parts of the underwear. And that's
I was a little unclear, sorry to interrupt, about whether other areas of the underwear were actually tested and were negative, or
Yes.
were, and I looked at the transcript volume 3 and I couldn't find a clear indication that other areas where there were stains or not stains were tested and found negative.
They were found to have no sperm or seminal fluid on them, no evidence of that. It's transcript 3, pages 170 to 171, 176 to 177, and 188 to 189, where they talk about the anorectal area and where the victim's bottom would be on the underpants. And so the sperm and seminal fluid is limited to the area of the interior crotch panel.
But for example, there were some spots observed on the back of the underwear, some small spots, I believe. And I didn't see evidence that those were tested. Because if those had been tested and they were positive, that could possibly support some inference about bouncing around on the bed in the underwear.
So
But
I
if they weren't tested,
suggest that those transcript volume sites will show what the lab tested, and that the only stains of sperm and semen found, despite the other testing areas, were in the interior crotch panel. But while that DNA is very probative, that's still a tough case for the Commonwealth, unless you then look at the mother's observations in this case. So the victim was at the friend, their friend of family. The defendant and his live-in girlfriend were friends of the victim's mother and her live-in boyfriend. She was there to hang out at a kiddie pool. The defendant's live-in daughter has a special needs teen. So the two girls go into the house. They're in there for 30 to 45 minutes, but then the teen comes out alone. The victim's mother, she's got a 5-year-old, so she goes right into the house to find out where her 5-year-old is. The bedroom door, the defendant's bedroom door, is shut, which the mother said was unusual. She went into the room. The victim is on the bed wearing just a t-shirt, no pants. Her vagina is visible. And
Counsel, is Mr. Benyon correct that there's no evidence about sort of where the underpants were at that point?
That's my understanding of the transcript as well. I don't dispute that there's there's no discussion of where her bottom pants or underpants are. The defendant's about 1 foot away from her. And here's the part where all the inferences point to guilt and not to innocence. The defendant's his belt is unbuckled and his zipper is down. When the mother comes in, he falls to his knees, his hands go to his crotch area, and he's about 1 foot away from the victim. The mother asks the victim what happened, and the victim doesn't answer. And on cross-examination, the mother testifies the victim was laughing. So the mother tells the victim to get dressed and they leave. And so I would suggest that that evidence shows there's no reasonable inference of innocence in this case. His sperm and semen are on her underwear and on her vagina. He is caught in this compromising position with a 5-year-old who's unrelated to him with the bedroom door shut. They're alone together. His pants are open and her pants are off. This is a very probative case of a touching. I agree with my brother. In this case, the judge instructed the jury very specifically, very high standard on reasonable doubt. To transcript 5, pages 73 to 74, that the Commonwealth must prove beyond a reasonable doubt the defendant intentionally touched the victim by ejaculating onto the victim's genital area. And I would suggest this evidence proves the Commonwealth's case, and I'd ask you to affirm this case and find the evidence sufficient. While the Croft instruction is not normally an instruction, it's usually an appellate tool for speculative cases or cases that require guesswork. And you'll see that in the Tavares case cited in the Commonwealth's brief.
Yeah, so that you're suggesting that it's really a question of law, whether there are two equally balanced inferences.
Yes, but here the judge actually gave that instruction at transcript 563.
Right.
And I would
So can
suggest,
the judge turn it into a question of fact by asking the jury to resolve it?
I would suggest that that instruction does not create a problem in this case because of the very specific reasonable doubt instruction given on this case.
Oh, it may not create a problem. I'm not suggesting it creates a problem, but I understood your brief to be arguing that because the jury convicted, they must necessarily have found that the evidence, the inferences were not equally plausible. And my question to you is, if Tavares says that's a question of law for the court, then how can we accept the jury's verdict as resolving that question? Because the jury only resolves questions of fact.
Well, I think because in this case they were given this instruction, which is not normally favored. And so what we have here is an indication that the jury found there were not two inconsistent but equal inferences, because they were told that if the evidence equally gives rise to either of two inconsistent propositions, then the Commonwealth has established neither. So I would suggest we actually have a jury finding, one, that the defendant intentionally touched the victim by ejaculating on her genital area, and that the jury did not find that there were two equal but inconsistent inferences to draw from based on these instructions. And touching someone with bodily fluid is sufficient to be a battery. Beal and Eberhard of saliva, and I provided the unpublished Grace case, which is touching by ejaculating on someone. So I would suggest that the evidence is sufficient. If you have no further questions on that, I'll move to the second issue. First of all, the defendant says that the judge excluded the evidence of the victim's statement that she never saw anyone's private and no one ever saw her private except for her mother and her doctor. And additionally, well, first, the judge did not exclude it. And that's a transcript 482, 85, and
He would have let
87.
it in, but he would have given a limiting instruction that it was
That it
only
goes
for
to-
the state of police knowledge, not for the truth. Is that accurate?
Yes, and also that they could have put in through the police officer, they could have put in that statement and that she had not made any allegation against the defendant. And counsel got this ruling. He had been mistaken as to what the ruling was. So the judge clarified it. Once he got the ruling, he talked with the defendant. He thought about it overnight and then he didn't present it. And we
So-
don't have a motion for new trial in this
Right.
case.
So what possible reason would there be for counsel not to present that evidence? Once counsel had decided he was not going to call the victim, which presents obvious tactical considerations about, do you want the jury to see you dragging this 5-year-old girl up on the stand and making her uncomfortable? What's the downside of calling the officer in, at least to say what the judge said he would allow the officer to say?
Well, I'm speculating here, but the downside is that the Commonwealth then would want to offer its favorable parts of the same interview so that the jury is not misled that the majority of the victim's answers were, I don't know, I don't know, I don't know, because she was 5 years old.
On what basis would those have come in?
To show more reasons why it's not just that she didn't make an allegation against the defendant, but that she was a 5-year-old who didn't know the answers to the questions. And so I think that in addition to that, the absence of a motion for a new trial really robs us of the thought processes of counsel. And that's how we find ineffective assistance of counsel. That balancing and weighing of what comes in and what doesn't come in and what the downside might be to offering evidence. That's a strategic decision under Brito, under Lynch, under Hudson. And you really do need the affidavit of counsel for this. And so this is not indisputably shown in the record, and the defendant has not made his burden to show ineffective assistance. But then we also look to what's already in the record, which one shows no prejudice to the defendant, but also shows why counsel would say, hey, I don't want to take the risk. If I put this evidence in, I don't want to take the risk that the Commonwealth's going to try to offer something from the sane interview, or two, call the victim, which would be open to the Commonwealth to rebut this inference. I'm not suggesting that we thought calling the victim would be
There was
helpful.
no reason, since the victim in the interview had said, I don't know, I don't know, I don't know.
Yeah.
It doesn't seem like
It doesn't seem like we would.
prospect of the victim getting up on the stand and saying, I don't know, is that detrimental to the defendant's case.
But we don't know what counsel was thinking. I think we can tell what counsel was thinking is he looked at his evidence and he said, I've got sufficient stuff here and I don't want to risk something else coming in through the Commonwealth's case. And so I'm going to leave it as it is. And then he made his argument using the transfer information and the state of the case, which included that one, the victim didn't testify, and two, that the jury knew that the victim did not answer her mother when her mother asked what happened here. The jury knew that the victim had not made an allegation because at transcript 3, page 62, she didn't answer.
Well,
There's
but
no
the fact that
allegation.
She didn't make it in that instant when defendant was still in the room doesn't make it cumulative to hear that she didn't make an allegation in the kind of carefully protected
Right.
atmosphere of an SAIN interview.
And finally, the defendant had presented that the victim was laughing during cross-examination. That's at transcript 3, pages 82 to 83. So the idea that he has made this assessment after getting this ruling and decided not to offer this evidence is something that this court should uphold as effective strategy unless the defendant shows indisputably in the record, which does not appear here because you don't have the information and from counsel, and he has gone forward and made valid claims in his closing argument. Finally, I'd like to address the medical diagnosis exception. I think if you look in the judge's findings, the judge said that the police officer could testify to these two statements of the victim because the police officer had been present and the judge had watched the video of it, all of which smacks of an SAIN criminal investigation sane interview. But what really does it is that we know that those statements occurred on the June 17th to 18th interview. And the medical examination was the June 8th interview. And then the doctor who did the medical examination, which is usually conducted by a sane SANE nurse, that doctor had testified that she didn't ask the victim the question, she got information from the mother. So there's good reason why the judge and counsel and nobody brought up medical diagnosis exception to hearsay, because it would be inapplicable here. This was part of the criminal investigation, which is why the police officer would have been able to testify to it. Obviously, the police officer would not have been able to testify to what happened during a sane examination by a doctor, at SANE by a doctor.
And even, counsel, even if the questions had been asked by an SANE examiner, say nurse, they still didn't really go to issues relevant to medical diagnosis, correct?
I think generally, I think you have to look every case on its facts. De Oliveira is the victim statements about her abuser to her doctor. But these statements don't go to something that would have created a medical problem if someone had looked at your genitals and you had looked at someone else's genitals. And so I don't think that that goes to medical diagnosis exactly in the same way we see in other cases. Where did someone hit you? How did this injury occur? Where should I take swabs from? Those kinds of things. So I don't think that they're precisely on point. But I can envision a time period where a doctor might be slowly asking those questions of a child witness, and then the Commonwealth would have to convince a judge in his discretion that these fit within the medical exception. They're not precisely the medical diagnosis questions.
So we don't know who it was that was conducting the interview, and we don't have a transcript of all the questions that were asked, but presumably the defendant has that. Those items were part of the record. And if the defendant believed that there was a strong case for the admissibility of these under 8034, that could be raised on a new trial motion somehow.
The judge actually reviewed the video of
right, but he doesn't
these
give
statements.
He describes a lot of the topics, but he doesn't give us a verbatim transcript, so we don't know every question.
I think the recording of it was made an exhibit for identification at trial, if my memory is correct.
Okay, counsel, unless my colleagues have any follow-up questions, your time has expired. And seeing none, thank you both very much. The case, and just on the Zoom hearing, you will see us occasionally look down or to the side. We are reviewing our case materials. We are not checking the box scores. So with that, I'll ask the clerk to please place us online.
You are live and on the record.
Thank you very much. Our next and fourth case of the morning is 2020 P387, 468 Group LLC versus ARGITECH Inc. And we will hear first from Mr. McGuire. Before you start and the clock starts, I just want to remind everyone that we have read the briefs, so we are familiar with both the facts and the legal arguments. So I would urge both of you to cut to the chase to the extent possible. With that, Mr. McGuire.
Thank you, Your Honor. It's Josh McGuire on behalf of appellants Patrick Hannon, AGRITECH Inc. and RHR LLC, and may it please the court. This appeal arises out of a jury trial that was riddled with errors of law concerning claims, jury instructions, and improper trial tactics. And I invite the panel to view this appeal through the lens of the implications for civil practice concerning a standard breach of contract claim, and for trial practice as well, if the issues that are identified in the appellant's brief are not addressed and are not remedied. And the implications are numerous, they're far-reaching. We have, as you've seen, a number of issues, including sub-issues that we've identified. But again, just to reframe them briefly, if the verdict and the judgment are allowed to stand, that means that in an otherwise rudimentary, straightforward breach of contract claim, there are a number of implications for how those claims are going to be practiced that I don't think are what we want to invite from practitioners and from the bar. It means that in cases where attorneys are entering into agreements with their own clients, that they can do that essentially without repercussions. It means that in every breach of contract action, an assurance that the consideration will be paid could be the basis of a claim for fraud. It means that in any breach of contract action, statements made in the negotiations about whether an additional party needs to be in the agreement can be the basis for a claim of fraud.
Since, Mr. McGuire, since you've made many arguments and you don't have unlimited time, can I just ask on your first argument regarding the Pollock rule, is it your contention that the jury should have been instructed to apply the Pollock rule?
It's our contention that the jury should have been instructed about the existence of the rule, the existence of the shifting obligation, the burden shifting to the attorney to make a showing that the influence had been neutralized by independent advice, and that was a burden that rested with the attorney with regard to that.
And so should the jury have been instructed that if they did not find that the attorney's influence had been neutralized by independent advice, that the agreement was not enforceable?
Correct.
And would that take care of the fraudulent transfer and 93A claims as well?
I'm not sure I understand the question. You mean if that instruction had been given?
If that had been given and the jury had said, no, we don't find this, the agreement was fair under the Pollock rule, could the jury have then gone on and found liability on any of the other theories, notwithstanding that the contract wasn't enforceable?
I suppose that technically the fraud claims were distinct from the contract claims. But I think that the joint venture and the liability of RHR for the underlying obligations of AGRITECH and Pat Hannon would be extinguished. The 93A claim, I believe, also would be extinguished. And I think that for reasons I'll get to, I think the fraud ones are separate because they rely on these statements made in the context of the negotiations, but that those aren't sustainable as fraud claims either.
Mr. McGuire, I read your argument with respect to the Pollock rule to suggest that if the instruction was not given, or if Pollock was not complied with, then the contract was void and should be set aside. But I didn't read Pollock to go that far. Do you have other authority for that proposition?
I don't, other than that is what the Rule 1.8 in its current iteration appears to suggest, that such claim contracts are void.
Let me ask you about that. I know that your proposed instructions included the text of Rule 1.8, but as I read through the transcript of the charge conference, it appeared to me that in the end, after discussion, you only proposed that your instruction number 2 be given, which was not the text of Rule 1.8. So haven't you waived that particular argument?
With regard to an instruction on the actual content of the rule, I think that might be true. The content of the rule was disclosed to the jury in the course of the cross-examination, and then in the charge conference, we instead relied on a request that the Pollock rule and the language from that be given as an instruction to the jury relating to the burden shifting.
And if you persuade us that you're correct on that point and that the Pollock or some version of the Pollock instruction should have been given, I want to ask you about what prejudice you think existed in light of the fact that Mr. D was vigorously cross-examined about Rule 1.8, made certain admissions about non-compliance with 1.8, and the attorneys were both permitted to argue in closing what the ethical obligations of Mr. D were.
Well, without an instruction that those ethical obligations operate as a matter of law to have the potential to void the contract, and without the instruction that it was the responsibility of Attorney D to show that any presumed undue influence had been extinguished through his through making sure that his client had independent counsel or an independent advice, the jury didn't know the significance of those violations and how they should have operated to void the contract.
Now, counsel, if your client, Mr. Hannon, had independent legal advice on the contract, There is no Pollock problem, correct?
Not necessarily. It would have to be shown that the independent advice that he received had been sufficient to neutralize the presumptive undue influence of entering into an agreement with his counsel. So it's not simply that the advice was available to him. It has to be that it was sufficient in nature to neutralize that presumption of undue influence. And here, that was a real question of fact that as far as what the evidence could support. There was no indication that Attorney D was even aware of communications between his client, with whom he was communicating directly, and the person who was presumably serving as the independent source of advice, his son, other than the allegation that it appeared that through the absence of either party's knowledge of redlining, there was a reason to believe that the son or somebody else had looked at these documents and redlined them.
Well, it went a little further than that, didn't it? Didn't your client, at least according to Mr. D, your client told him that the contract was being reviewed by his son?
I think that there was testimony that his son had been looking at the documents, yes. But that's different from whether or not he had received adequate advice from the son with regard to the neutralization of the undue influence. And I would say significantly on this point, the cross-examination was not permitted to include questions about the ethical obligation for the attorney to be dealing directly with counsel instead of the represented party in negotiating the agreement. That was
let me interject a big picture question about this issue. I understand the concern raised by the Pollock decision to be a situation where an attorney has undue influence over his client in the course of a transaction. This, it struck me, was perhaps different in that your client was the one with the expertise in the soil reclamation business, and your client was the one that proposed it, and your client was the one that proposed the percentage recovery to which Mr. D would be entitled. What's the best evidence of undue influence in this case?
The best evidence of undue influence starts with the fact that the premise that this was a soil reclamation project, I think, is flawed, Your Honor. This was a contract for services that Paul D, consulting services, essentially legal advice that he'd be providing to the project. It wasn't within the sphere of expertise of Pat Hannon. It had nothing to do with soil reclamation other than that the business that was receiving the advice from Paul D was a soil reclamation business. But the evidence of overreaching is the fact that 5% proposed by Pat Hannon on account of the prior money that he'd owed to Mr. D was rendered within the contract as a 5% gross figure, not net, that the contract that they entered into did not extinguish Paul D's claim for the $400,000 that he was owed previously, and that the work that he was required to do to earn that money was minuscule in comparison with the projections of the gross revenues, could be delegated to somebody else without repercussion, and in many other respects were deeply unfair to Mr. Hannon.
May I ask a question about your fraud claim or your challenge to the fraud liability? You said that the statement that PJ and RHR don't need to be in the contract is not a statement of fact. It's an opinion. Couldn't support a fraud claim. But the statement went beyond that. It wasn't just PJ and RHR don't need to be in the contract, but also that he understood between us, and I believe that's referring to PJ, that he was a party. He just didn't want his name to appear in the document. So how is that not a representation of current fact that could have induced the plaintiff to enter into this agreement and support a fraud claim when it turned out to be false?
The statement that PJ did not want his name in the document, but otherwise understood, well, there's two parts to that. One, he didn't want his name in the document. And the second, I suppose, is that he understood that he was.
So it's probably true that he didn't want his name in the document, but what about the part where he says he understood between us, he's a party?
Certainly. We're talking about a negotiation between Pat Hannon and an attorney of 40 years who routinely entered into agreements. With regard to that particular phrase that he understood he was part of the agreement, I would suggest that that one might be a factual, and I suppose could have been interpreted as a misrepresentation, but it's not reasonable for any attorney to rely on that when they're negotiating an agreement when there's a separate legal entity that he knows exists that is saying, I don't want them to be a party to the agreement. To say that an attorney—
Counsel, you're saying that it's unreasonable as a matter of law, or is it a matter of fact that was within the jury's purview to decide?
I think that in order for it to meet the elements of fraud, it would have to be that that was reasonable for him to rely on that statement. I do not think that an attorney relying on a representation from a non-attorney, his own client, as to whether or not some party needs to be in a contract, it's possible for that to be reasonable as a matter of law for the attorney to rely on that. It's the sort of thing that attorneys have specialized knowledge of that lay people don't. The implications, the legal implications for somebody either being listed as part of that agreement or not. Beyond that, I would say that it's difficult for him to show that he was harmed by that misrepresentation to the extent that it was made and could be fraudulent. But the effect of that would be to turn any negotiation statement about who is or is not in a contract potentially into the basis for a fraud claim. I don't think that it could be reasonable for an attorney in particular, or any party to rely on that as something that they can then claim as fraudulent.
Can I ask you a question about your damages, excessive damages argument?
Yes.
I understand your point that the failure of the jury to, or the jury's decision not to subtract out the $53,000 already paid from the $276,000 that would have been 5% of gross revenues, arguably, was an error or perhaps inexplicable. But what's our hook for either ordering the remitter or a new trial, I suppose is what you're looking for? I mean, we can do that where the award is greatly excessive or a miscarriage of justice, but does an extra $53,000 on 276, or what otherwise would have been, I don't know, 222, 23,000 really meet either of those standards?
If it's just that delta, no, I don't believe it does. Part of the problem is that the jury's calculation, and as well as the judges, because they were done in a very similar fashion, is based on every dollar that flowed through the bank account in connection, ostensibly in connection with this project. But there was no definitive evidence shown, or any evidence shown, that this was in fact the only project that was being undertaken. That's an error that also infects the 93A claim as well, I believe. But in any event, so it's really not a question of that 53,000. But at the very least, I think that the 53,000 and failing to account for that sort of informs the court as to how the jury had been swept away by the other various evidentiary errors in the course of the trial to believe that simply anything that they could possibly revisit upon Mr. Hannon or the other defendants was appropriate at that stage.
Unless my colleagues have any further questions. Thank you very much. We'll hear from Attorney Heineman.
Good morning, members of the court. My name is Michael Heineman, and I represent 468 Consulting Group, LLC. From the first sentence of my opening statement in the underlying trial right through the closing and all the evidence that was put in, this case was about a father and son, as you know from having read the transcript, working together and committing fraud, breach of contract, 93A violations against my client, Paul D. The claims in essence were that the father and son played this shell game with the corporations to avoid paying 468 the monies it was owed. And I think importantly for our discussion today, the trial court, having reserved the 93A to herself, found as fact that the defendants here did commit those acts, found knowing and willful violations of 93A against Hannon AGRITECH, and R&R. The jury, of course, also found breach of contract against Hannon and AGRITECH and found fraud.
On the 93A,
Yes.
I'm having a hard time seeing, and the judge didn't actually find that whatever breach of contract may have occurred here was intended to secure unbargained for benefits to the detriment of the plaintiff. And the law is pretty clear that a simple breach of contract is not a 93A violation. You've got to show that extra element of it, the breach being intended to secure unbargained for benefits. The judge didn't find that. I don't see how it occurred. So how can we uphold the 93A liability?
Well, I would suggest, first of all, under the Anthony's Pier 4 case, 411 Mass 451, conduct in disregard of a known contractual arrangement intended to secure benefits for the breaching party constitutes an unfair and deceptive act. Judge Sullivan referred to the Mass Ioneer case, 552 F 3rd 47, and wrote that there's no plausible explanation here for the cessation of the payments other than a deliberate decision to spend the money on a new home, improvements to that property, purchase of an additional home in Maine, rather than making payments to the plaintiff.
Well, but how did the use of the money for that other purpose constitute any detriment to the plaintiff beyond the detriment he already allegedly suffered by not being paid the gross 5%? I mean, the fact that the money was used for something else rather than left to sit in RHR's account or ARGITECH's account doesn't seem to be an additional harm. And the cases require unbargained for benefits to the detriment of the plaintiff.
Well, I think that I agree with Your Honor exactly that there is not an additional loss suffered by my client, but I don't think the cases require an additional loss. It is the loss itself being caused by this act. I agree with you that the underlying loss is a breach of contract loss, but I don't believe that the case law suggests that ends the analysis and no 93A can ever arise from a breach of contract. I would respectfully suggest that the using the money to do something else other than pay my client in these circumstances, as found by the judge, can rise to the level of a 93A violation. I don't know if I've answered that question. I hope I have.
Well, you've got a lot of ground to cover, so.
Okay. The issue of the professional responsibility and this issue of Pollock, there absolutely was a waiver of any request that the rule itself or the comment be read to the jury. The issue was, I suggest, that Judge Sullivan made a determination that this contract fell within the comment to the rule, and therefore the rule didn't apply. The example she gave, and you'll see it in the transcript, was, well, yes, there's a law about murder, but I don't need to instruct this jury about murder because it doesn't apply in this case.
Right, but that exception in the comment applies to transactions in which the client is generally engaged and the attorney is engaging in it on the same terms as every other member of the public or the relevant industry to whom the client offers that service. The client here was offering consulting, if the client is ARGITECH, offering consulting services on how to run a soil reclamation.
So in other words, if that's what the judge was thinking, why wasn't she wrong?
Why wasn't she wrong?
To think this falls within the exception to the exception set forth in the comment.
Well, because the contract was suggested by Mr. Hannon. It was a contract in with consulting for a soil reclamation business. Mr. D, 468, had never been involved in this sort of business before.
But I think the question is, this is not a kind of deal that ARGITECH was offering to other members of the industry. This 5% gross revenue consulting deal with Mr. D or 468 group.
We don't know. There's
one-off, a unique transaction. It's not something that the client is in the habit of offering to everybody on the same terms, so that the attorney has no fit. You know, if I'm the attorney for McDonald's and I go in and buy a hamburger, you know, I have no particular obligation to show that that's a fair transaction in order to enforce some liability coming out of that transaction, because they sell hamburgers on the same terms to everybody. But this was a contract for something quite different.
I would just say on the status of this record, there was no discussion, no evidence about whether this was a one-off or something common for Mr. Hannon to have done. What we do know is that Mr. D had never done this before. So
Mr. Heineman, if your first point is correct, that is that the request for an instruction on 1.8 was waived, the reason the judge didn't give the instruction doesn't really matter, does it? In other words,
I agree with that, Your Honor. Yes.
And so that would leave us with a question of whether or not the judge was obligated to give the basic Pollock instruction that was requested.
Right. This comes down to the Pollock issue. And that's why I would suggest that the arguments I made in my brief, as you saw about Pollock, were twofold. One is Pollock predated 1.8. And 1.8, of course, was implemented, and including the comments, by the SJC. And so I think we can presume the SJC knew what their prior decisions were.
Are you telling us that Pollock is no longer good law?
No, no, Your Honor. I think Pollock is still good law. However, when the comment of 1.8 applies, which this judge made the decision it did, that concept of burden shifting is not applicable, is the argument I'm making. And I would suggest that the findings of the court with regard to this being a soil contract and not a legal contract like Mr. D was used to doing as a tax lawyer are supported by the evidence. There were numerous references throughout the trial about this being a soil contract, a dirt contract. In fact, there was testimony going through all the different times that soil was mentioned and dirt was mentioned. So I would suggest the court was exactly right that this was not the sort of contract that required an instruction on burden shifting.
Let's assume that we come to the opposite conclusion and decide that the judge should have given instruction number 2 proposed by the defendants. Does that end our analysis?
I don't believe it does, Your Honor, because I think it'd be harmless error in any event, especially given the fact that the judge sitting as fact finder at a 93A made these findings as well. And so she obviously was aware of this burden shifting to the extent it existed and was comfortable that the evidence supported the finding that there was no undue influence, that the burden had been met. In fact, my client did testify to each of the elements of Pollock. It's at volume 1 of the appendix, page 553. He testified that the terms were fair, they were fully discussed, they were read and understood by Mr. Hannon. That's evident from the document itself because he initialed each page. And on the state of this evidence, it's clear that a jury would be warranted in finding, as I believe it did, and as certainly as Judge Sullivan did, that he did have the independent counsel of his son, PJ. The testimony was more than just that the red lines suggested that PJ was reviewing it. There's testimony in the record that Patrick Hannon told my client that his son PJ was reviewing the contract, and at the final version that PJ, the lawyer, told his father to sign this agreement. So I don't know what else the court might have questions about. I would suggest that the evidence submitted at trial was more than adequate to support the findings of breach of contract and fraud on the part of Hannon and ARGITECH. I would suggest that this concept of joint venture is important. And the defendants argue that somehow you can't have a joint venture breach of contract. So I would like to talk about that briefly if I could.
Before you get to that, let me ask you a procedural point on that.
Yep.
It didn't appear to me that there was any objection to the joint venture instruction rather, either at the time it was proposed or at the close of the instructions. If that's true, have the defendants waived that?
I certainly think they've waived them the argument that the instruction on joint venture was inappropriate. In fairness to the defendant, I think they're arguing that somehow joint venture doesn't apply to a breach of contract claim, a slightly different concept, and that it shouldn't have been on the slip that way. And so if that's what they're arguing, as I understand their brief, I don't think they waived that, in fairness. I think they did argue that both at the charge conference and during their every interaction with the judge. And so I wanted to address briefly why I think joint venture does apply. The case law on joint venture, while not voluminous, I think makes very clear that it does apply. All of the cases start with the principle that joint venture is a partnership of sorts. It's typically for a limited purpose as opposed to a general partnership. Of course, in a partnership, every partner is liable for the acts of their partner, whether they are negligent or a breach of contract. If my law partners and I enter into a contract and I just happen to be the one partner who signed that contract, if that contract is breached, the offended party can sue me and my partners. That essential element of a joint venture, I think, is exactly the same. And there's no case cited by the defendants that it shouldn't apply. What they cite to is a case that says most of the time, joint venture is used in accidents.
Can you cite any case where joint venture has been applied to a breach of contract claim?
I can't. Most of the joint venture cases either involve a dispute among the parties themselves and not a third party, which is the case we have here, or they do involve an act other than breach of contract that I have found in the reported decisions. But what I would suggest is persuasive here is that all of the cases talk about joint venture being akin to a partnership. And there's no question that joint venture applies in the civil context, in addition to the criminal context. If two, as you all understand, I don't need to explain joint venture in the criminal case, but here, even the defendant conceded that joint venture applied to the fraud counts. And their only argument was it didn't apply to the contract count. I would suggest to you that for the same reasons that if this was a partnership as opposed to a joint venture, the breach of contract would apply to both. It should in a joint venture. And so the jury's finding on breach of contract and fraud as to Hannon and ARGITECH, when the jury makes the finding as after being properly instructed on what joint venture was, that RHR was engaged in a joint venture with those two, I'd suggest that the breach of contract and fraud counts should stand as well, and the joint venture counts against RHR. So unless the court has any other questions, I'll rest on my pick.
Just related to that, I mean, why isn't the contract claims against RHR more properly conceived of some kind of reach and apply or collection action type claim than it is direct liability under a contract to which they explicitly were not a party?
Maybe I should have played it that way, Your Honor. I didn't. The case was tried under the joint venture, and I think the joint venture applies. I don't really have a good answer to that question.
Do either of my colleagues have anything else? Hearing none, I want to thank both counsel. Excellent job by both sides, and we particularly appreciate the collegial nature and tone of the arguments. So thank you very much for your time. And with that, we will first hear from Mr. Briansky.
Good afternoon. May it please the court, Richard Briansky on behalf of 3143 NAGOG Park LLC, who I will refer to throughout this argument as the landlord. Likewise, I'll refer to the EIQ as the tenant. Through this appeal, the landlord seeks to obtain the benefit of its bargain. That is the post-termination damages that was set forth in the terms of the lease. There is no dispute that two sophisticated parties negotiated and agreed to the terms of a written lease. That the plain language of that lease manifests the collective intent both of the landlord and of the tenant to allow for what I call post-termination damages. That is acceleration of rent after the termination before the end of the lease. In this case, there's also no dispute that the tenant breached the lease before the end of its term, that the landlord was...
Can we stop there?
Sure.
Because as you know, that's an issue raised by the cross appeal. Should we get to that issue? Where was the breach here that allowed the landlord to exercise paragraph 17? I mean, you have the letter from Vetstein, which certainly can be read as we are not going to pay rent after the end of May, but was there a present breach that allowed, on summary judgment, through which could be resolved on summary judgment as a matter of law, that there was a breach here?
There was no payment of April rent or the utilities, both of which was found by the...
But no, I understand the arguments, but tell me if I'm wrong, was there a notice of delinquency on the April rent that they did not comply with?
The letter references a notice, but I have not seen one in the record, the notice of termination. Sorry, it's a notice of default that was issued, excuse me. That was marked as Exhibit 13.
So if we go to Exhibit 13, you're saying it will establish in no uncertain terms that they had defaulted on the April rent and had 5 days to cure it?
I don't think it specifically references a 5-day to cure period. It is referenced notice of default and not notice of termination. And there was no meaningful exercise of any right, nor is there evidence of any exercise of any right to attempt to cure. And that would have been relatively simplistic in this case. It would be simply paying the April rent, but there was no effort to do so. And I think, you know, there may be a hyper technical focus on what the language of the letter states, but to the extent they wanted to take advantage of the opportunity to cure, they being the tenant, certainly had the ability to do so and failed to. It was never their intent. And it was made unequivocally clear, I think, in the Vetstein letter. And then there wasn't even an effort after that to pay the subsequent month's rent, which he represented he would pay in the letter. In fact, to the contrary, they took the position that they had the right to surrender, and part of their breach is our failure to release the security deposit.
Okay, counsel, I interrupted where you wanted to go on the damages. Turning to that issue, paragraph 17A says essentially the measure of damages is A minus B. And throughout this case, your client appeared to focus on the A and frankly didn't want to talk about B until finally pressed. And then they made the claim that B was 0, something that the judge rejected. What required, given the state of the evidence, what we required the judge to put a figure other than 0 on B?
Well, I disagree with your conclusion that the judge rejected the evidence. I guess you can make that inference from the verdict itself, but there was no specific factual finding by the judge that she rejected that evidence.
But that's because the parties waived the Rule 52 finding requirement.
Yeah, that's accurate. I'm not disputing. I'm just clarifying. but to answer your specific question, there's nothing in the lease that prohibited the zero value, and that zero value was supported not only by Will Deschler's testimony, who testified in detail as to the justification for that zero amount. Likewise, there was an expert by the name of Rory Walsh who testified, and arguably that testimony was on his efforts to release the property, but that testimony in and of itself demonstrated the zero valuation. In fact, and what's unique about this case is because of the protracted period, there was actual damage at the time of the trial. Typically, we rely on acceleration provisions to estimate the amount of rent in the future. But here, there was actual damage. So there was no dispute here that the parties bargained for these post-contractual termination damages. These post-termination damages, and that there was actual damage. We didn't have to rely on the formula anymore. We know that there was damage. How do we know? Because there's evidence in the record that for at least 1.5 months, 1.5 years, 1 year and 5 months, through diligent efforts, it took to get at least a single tenant in the building. And I think what's more compelling here is, to the extent there was a challenge to that amount, that zero valuation, why isn't it incumbent on the defendant or the tenant in this case to introduce evidence to contradict it? Not to say that it wasn't sufficient enough to meet the standard, because it certainly was evidence at the time that a judge could reasonably rely on. And it was supported not only by Mr. Deschler's diligence that he did, and he testified as to neighboring properties that had low vacancies, which supported his conclusion, but this Rory Walsh made an independent, active effort to lease these properties. And it took him 1 year and 5 months. Now, what is required at the time that they issue, and I think this is what's unique about an acceleration clause, it assumes that you're going to make certain assumptions, right? Because you're estimating. It's within, both parties agreed on a specific formula, but those variables were going to be by their very nature estimated. They don't know what the actual utilities are. They don't know what the actual CAM charges are. They don't know what some of these variable rent numbers are, but they estimate at the time. And the whole benefit of that provision is to allow them to immediately collect what they approximate the rent to be. And there's certainly nothing wrong with an estimate of zero for what they call the fair market offset. There's certainly nothing that prohibits that zero valuation in the lease. And I think what's more compelling in this case is there's nothing in the lease that requires the disclosure of the calculation that the landlord used. It definitely provides a formula, but that formula is supposed to be immediately executable, right? It's supposed to be self-executing. Otherwise, you get a case like this where that formula is of absolutely no value to the landlord. The landlord never got what it bargained for. Instead, it had to wait 5 years, engage.
Counsel, why isn't this analogous to, say, ordinary tort, car crash, plaintiff is injured, the permanent injury, it'll affect her ability to get employment. So we know there's been harm, but there's no witness put on to testify about how precisely her future earnings will be harmed by her physical injuries. Wouldn't the jury or fact-finding judge in that circumstance be free to say, I'm sorry, there was probably injury, but there was not evidence to support a figure, so we're going to say zero.
But I guess the distinction I would make, and I would make two distinctions. The first is factually there was evidence, and the evidence was zero, and it was supported. Now the court may disregard that evidence, and the tenant was certainly free to put on evidence contradicting that zero value to allow the judge different numbers. And we're not saying the judge should have in totality adopted the number. What I am saying is that both parties agreed at the time to this contractual number, this contractual formula, that it was absolutely applicable based on the breach at the time. And it's fairly simplistic to apply it. You may disagree on the variables, but the fact is that the parties intended at the time they contracted to allow for the collection of those damages.
Okay, counsel, there are a lot of other issues in this case. Can we turn to the threshold issue on the cross appeal in terms of whether or not it's properly before us or should be properly before us? Is it fair to assume that your client has shown no harm from the failure to docket a cross appeal under circumstances where neither party appears to have noticed this until our clerk's office pointed it out?
Yes, and I don't think we've alleged any prejudice, if that's what you're asking.
No, I'm just trying to.
Yeah, that's accurate.
So the argument is simply this is not this is a garden variety error, and therefore that's not enough. End of story.
That's correct. And it was a perfunctory motion that was filed to docket late. And I think that's what, if you ask me, that perfunctory motion, which didn't articulate with specificity, which is what's required, good cause shown, is what justified the denial of the motion. And that's incumbent on the tenant to identify, and oftentimes with an affidavit to support the good cause. And I think here you don't have any of that, or there wasn't originally that evidence to show good cause. I do believe they filed a motion for reconsideration. That's my recollection generally. But again, I think that's the threshold issue incumbent on the tenant. And I think they've failed to articulate that good cause standard.
Okay, turning to the issue of the alleged disproportionate attorney's fees award. If we were to uphold and this is a hypothetical, if we were to uphold the zero damages award, why wouldn't we also have to assume that there is a disproportionality here that requires at a minimum further thought?
Because I don't think there was a disproportionality, and I don't think merely because you uphold the zero amount value that justifies reducing the legal fees. In fact, it's not only success driven, the formula. And I think what the judge recognized, who was with the case from the inception to the conclusion and made this specific inclusion of zero, but nevertheless approved that $200 and some odd thousand in legal fees, was in the best position to assess the value of the services provided, actually heard the testimony, saw the work that was required in this particular case. I think recognized that 5 years of fairly, I was not involved in the underlying case, but I perceive it as fairly contentious litigation. This wasn't a perfunctory.
I think that's fair to assume.
Yeah. So I think that there was an extraordinarily, and even the case, which was just on damages alone, I think was 4 or 5 days of testimony. And I forget how many exhibits maybe.
But actually, isn't it accurate to say that if you factor in the return of the security deposit, there was actually a negative verdict here, putting aside the attorney's fees?
Well, and that's sort of why we're coming back to this post-termination damages claim. And I know that's not specifically what you asked, but that the landlord did nothing wrong in this circumstance. It's the tenant who left early, and we're completely deprived. And that, I think, identifies what the real prejudice here. Like the tenant left before the end of the term, and now doesn't have to pay any money. I mean, that's contrary to the agreement that they signed. The landlord hasn't done a single thing wrong in this case. The landlord complied with its obligations. It was the tenant that left early. And that gap of time should be compensated. There was an agreement to compensate them, and there's actual damage to show it. We're not asking you to speculate anymore. We know for sure. And the law doesn't require precision with damages, right? And especially here where there is a liquidated damages provision. There was certainly ample evidence there. And that's really the wrong, to me, when you look at that verdict sheet that happened. It's not that there wasn't a contractual entitlement, and there was absolute damage. Anyone looking at the record would know that there was damage. In fact, it's almost assumed in these particular cases, absent of showing that the rent that we could receive skyrocketed, which there was no showing, in fact, just the opposite, there's going to be a loss. And whether it's $2, $10, $15, it's more than zero.
Okay.
I see that my time is
yeah,
up.
I speaking only for myself, I have one more question or related questions. As you know, both sides are seeking appellate attorney's fees on different theories and issues. Focusing on one such issue, why isn't the arguments that you raise based on paragraph 17B frivolous, in the sense that they were not raised below, in fact, to the contrary, were disavowed at various points in the course of litigation?
I will concede that they were not pressed, but Mr. Eisenberg, even in his opening argument, identified 17B as a potential. Likewise, there was evidence in front of the judge as to those amounts. And that's really what we're trying to show with the 17B argument, is that there were damages that were compensable. And that was just an alternative formula to collect those damages. And to me, what that formula was actual damage. And that's something that under the lease itself, we should be entitled to under cumulative remedies, which was argued under the paragraph 17D. You know the lease better than I do.
Do either of my colleagues have any questions? Hearing none, we will hear from CYGILANT, however you pronounce it.
Hey, please the court. My name is David Eisenberg and I represent CYGILANT Inc. This is a commercial lease dispute and CYGILANT was the tenant. The landlord filed this notice of appeal and they raised two issues. One is whether, as a matter of law, the court below committed error in awarding zero damages under paragraph 17A4 of the lease. The other issue is whether the court abused its discretion in striking the testimony of one of NAGOG's damaged witnesses. Neither argument has merit. And I would suggest that this appeal was filed simply because NAGOG wanted to take advantage of the lucrative interest on the attorney's fee award in the amount of $230,000. And I'll get to that in a minute. But as Your Honor points out, this case basically involves a failure of proof. The benefit of the bargain here, as Mr. Briansky says, is paragraph 17A. Paragraph 17A contains a formula for damages. One, the first component is the accelerated rent component. That's the only component that NAGOG focused on, and that is the Cummings case. But this isn't the Cummings case because there was a second component. The second component was the credit due the tenant for the then present fair rental value. And therefore, I would disagree with Mr. Briansky when he says that this lease assumes that the landlord is going to recover damages under the formula in 17A, because the assumption is just as easily made that the then present fair rental value of the premises is the same as the accelerated rent. And the court wasn't bound, given that NAGOG had the burden of proof, of finding something else, particularly.
Counsel, I hear all that. There is some additional evidence here, though, in terms of the vacancies at the time in other units in the plaza. And obviously we have the after the fact evidence that this property stayed vacant for, I think it was a year and a half in addition. So there is certainly direct evidence that it was a down real estate market. So while the judge was not bound to look at the present value of the leasehold as zero, couldn't she have set it at something between zero and the 400,000 and change that they were seeking? I'm sorry that you were claiming was the present value of the lease.
I would suggest not, based on the way this case was tried. But in addition, there was also evidence, as Your Honor knows, that NAGOG was leasing other properties at the same amount that CYGILANT was paying at the time that it vacated. And also, Mr. Goodman testified, and this was an admission that we put into evidence, that they actually marketed other properties in the same building ahead of marketing CYGILANT space, and that those other spaces were leased much earlier. So we really have no evidence as to what that reasonable period of time to relet might have been. In addition, NAGOG never really introduced it as the reasonable period of time to relet. And I would suggest that the court really didn't have evidence as to what that would be, that just to say that the actual time that it took to relet the property without considering all these other factors makes the judge bound to accept that testimony. Further, there was significant evidence in this case that from the get-go, CYGILANT was attempting to determine how NAGOG calculated its damages. From the depositions, first we sent out an interrogatory, and NAGOG objected to answering the interrogatory and said that we had asked more than 20 and therefore it wasn't going to answer it. So we sent out a 30B6 notice. In the deposition, and they presented Mr. Deschler as the 30B6 witness on every category, including damages. And we asked him, Mr. Deschler, what was done to calculate damages? What are the elements of your damages? What did you do under 17A to calculate those damages? Mr. Deschler disavowed any knowledge of how the damages were calculated. Instead, he pointed to another individual at NAGOG, Mr. Natupsky, who did all the calculations. And as the court will see when it looks at the deposition transcript, which is in the record of Mr. Deschler, he had no idea what Mr. Natupsky did. He didn't ask Mr. Natupsky what he did. He said, and this is Exhibit 17, the court can see exactly what Mr. Natupsky did. And that was, he calculated not the accelerated rent under 17A. What he calculated was how much rent would be due from April 1, 2015 until the end of the lease. And what's significant about this is that those instructions to calculate that amount were done pre-default. This was done in March of 2015, before NAGOG terminated the lease. And so there was no focus on the second component of 17A, which was the credit to the tenant. The only focus was on how much rent would come due from April 1st till the end of the lease. And in fact, NAGOG carried that forward from April 1st through the end of the lease until after discovery, until after summary judgment, when it submitted supplemental answers to interrogatories. And that's the first time that NAGOG ever woke up and said, oh no, the damages are different prior to termination than they are after termination. And then all of a sudden the date changed from their calculations from April 17 forward. And again, they claimed that Mr. Natupsky did that calculation. When Mr. Natupsky was deposed the day before trial in the court-ordered deposition, Mr. Natupsky testified, he only ever did one calculation. That was the calculation in March. And therefore, we have this huge runaround to get to the damages. Mr. Deschler claiming this, Mr. Deschler saying that, but in fact, he had no knowledge of the damages. That was the position that they took. We also deposed, Your Honor, Mr. Goodman, who verified the damages in the counterclaim. Mr. Goodman had no knowledge of how the damages were calculated. That was his testimony. And in fact, what he did was pointed to another witness at NAGOG who he said calculated the damages, and that was the CFO, Richard Anton. Richard Anton, when we deposed him, said he had nothing to do with the calculation of damages. He has no idea what was done. So we're getting this huge runaround in terms of how these damages were calculated and what they are. And there was evidence in the record, in terms of that there were other properties being relet at the same price that CYGILANT was paying. And so this is really a case of a total failure of proof on behalf of NAGOG. And I would also suggest that the court wasn't bound to accept the credibility of Mr. Deschler with respect to any damage testimony that he provided, particularly given his prior deposition testimony, particularly given that he had numerous opportunities to raise this issue as to whether the damages were zero, the credit was zero all along, and whether he made that communication to Mr. Natupsky, which, by the way, Mr. Natupsky sitting in the deposition the day before the trial, when Mr. Deschler makes this bald assertion that he always claimed it was zero, and that in fact, when he gave Natupsky the instructions in March of 2015, oh, Jeff, assume it's zero. Mr. Natupsky, I then deposed him immediately following Mr. Deschler, and I asked Mr. Natupsky quite plainly, did you ever have that conversation with Mr. Deschler? No, he never said that. The only instructions I had were to calculate the rent from April 1, 2015 forward and provide a present value. And that's the only calculation that Mr. Natupsky ever did.
Okay, counsel, I think we understand your arguments on this. You may want to turn to the other issues.
Well, if I don't know if there's any questions about excluding Mr. Natupsky's damage testimony, but I suggest that's also a frivolous argument that Mr. Natupsky at trial provided a number of damages which had never previously been provided. And given the entire history of the damage testimony and the discovery of this case, there was no abuse of discretion in striking that testimony.
I think we get that one too.
Well, in that case, Your Honor, I'd like to move to our cross appeal, if I may, and argue the issue with respect to the attorney's fees.
Yeah, well, before we get to the attorney's fees, let's get to the threshold question. Here, a single justice of this court denied the motion to extend the time to docket the cross appeal and pay the fee. Were we to determine that the cross appeal was nevertheless before us, wouldn't we have to determine first that the single justice abused her discretion in denying that motion?
I don't think so, Your Honor, under 3A, where it provides that as long as a notice of appeal is timely filed, the court has equitable powers to consider a meritorious appeal, and that this is one of those cases where the appeal is meritorious and also where there really is no prejudice to NAGOG. It wasn't a chosen course of conduct on my behalf. We didn't unnecessarily stretch out the appeal. It was always our intent to pursue this appeal, and everything else that we did in this case, evidence that we intended to pursue this appeal. When the notice came out that NAGOG's appeal had been entered and each appellant and cross appellant needed to file a docketing statement, we actually filed our docketing statement first, and that was accepted by the court. And in fact, on the appeal court docket, for the longest time, it was the issue that we presented in our cross appeal that was identified. I know it's not binding, but was identified as the issue in this particular appeal. Further, when we filed our motion to file a supplemental appendix, we identified the issues on the cross appeal and that those materials would be included. That was accepted by the court. And we didn't do anything to stretch out these proceedings.
Okay, counsel, time is getting rather short if you want to get to the merits of the cross appeal.
Well, the merits of the cross appeal is that this attorney's fee award is grossly disproportionate to the amount of damages. And I would suggest this case is very similar to the TAL case where NAGOG sent out this termination notice and demanded a very high dollar amount to resolve this case, wouldn't take a penny less, was totally intransigent in terms of how it would negotiate from there. We attempted to—
Okay, counsel, the various arguments you're trying to get us to consider now were made to the trial judge. This case is somewhat unusual in that all the attorney's fees issues were argued to the trial judge. So this is not a case where we can say, oh, she must not have considered A, B, and C because, that they were made to her in closing. This is also a case where the parties waived their Rule 52 findings. Tell me your view of what our review of this issue is. Namely, is it like the review of the merits of the appeal in chief, where you argue we should uphold the verdict if under any view of the evidence, it could make sense?
I would suggest it's an error of law with respect to the attorney's fees based on the TAL case. And I would also suggest that when arguments were made to the court below, there was no finding, that we argued that in fact their damages were zero. And this is a case very similar to TAL where the numbers that NAGOG kept throwing out there kept increasing and increasing, even though there was no basis for them to continually increase. And in fact, in the deposition that was taken the day before trial, we asked them about every damage number in their answers to interrogatories, and they couldn't identify how any of those numbers were calculated. And the court below had the testimony of Mr. Maffey, and they simply applied the Lithicum factors straightforward. And I would suggest that the court just adopted the Lithicum factors based on the credibility of Mr. Maffey. And there's nothing wrong with that, except in this particular case, a further analysis is required. And it's not just a straightforward,
Well, further analysis required. It's interesting because those cases, I don't believe, arose in the context of this case, where again, the Rule 52 findings were waived, and the arguments about the low recovery, even though the precise recovery had not yet been determined, those arguments were made. So this is not a case where we can say, oh, the judge didn't consider this. Send it back and think about it some more. And by the way, would there be anything wrong if the judge's thinking were essentially, I am going to determine there are zero damages here because of, in your words, a failure of proof. But that said, we know there was some not insignificant harm here. So I'm not going to take this into account in setting the amount of attorney's fees as by way of rough justice. Would that be within her discretion to do?
I still would suggest it's an error of law in the context of this case. And while the judge was fully aware of the discovery abuse that took place in this case, these fees were largely driven by the election and the choice that the landlord made to proceed under 17A and refused to consider any alternative other than that. And it was an amount that drove this case and drove how the case was conducted. And then there was all the gamesmanship throughout discovery. And I don't disagree that it was contentious and there was a lot of fees that were actually incurred. But the issue is, under this lease, the landlord's entitled to reasonable fees in advising the client. And I would suggest that it's not reasonable fees in advising the client where the client never considered the B component of the damages. And again, I think this is clear from Exhibit 17, where Mr. Deschler says, he sends the calculation to CYGILANT and says, all we did was an MPV, the remaining lease obligations. So they never considered it. And that's what drove this case.
Okay, counsel, your time is up. I have one more question on the summary judgment argument. Is the statement of material fact in the record?
I don't know for certain. I thought that it was.
If it's not, that's a question, or a hypothetical at least. How could we rule in your favor on the summary judgment issue on that?
I thought it was in the record, Your Honor, because I believe in our brief, we cited to certain testimony that would evidence from the statement of material facts. I might be able to find it quickly. I know I'm out of time, but I believe that when in our summary judgment portion of our brief, we do cite to...
Counsel, we can scour the record and confirm it one way or another. I want to see if either of my colleagues has a question. Seeing none, the case is submitted, but I do want to just say one thing, and that is channeling my former colleague, Fred Brown. This is a case that is, as best I can tell, only about the money. This is not a divorce case or a child custody case. And I cannot remember, I've seen a lot of complicated commercial cases, but I cannot remember a case where the potential outcomes of this appeal vary so greatly for the two parties in terms of, again, then when you fit the different cross appeals together and how you come out, one side or the other could be extraordinarily unhappy with how we rule. And I would add that it is possible that both sides would be extremely unhappy with how we would rule. And for example, a question we didn't get to because we ran out of time is, I'm not at all sure that were we to accept the argument of CYGILANT on summary judgment, that this would be in CYGILANT's long-term interest. So all of this is to say that we will do our job in resolving this complicated appeal. It's an interesting case, and we will have to sort out these issues individually and as they fit together. If the parties have any interest in resolving this amicably, you might well come to a solution that you would be much happier with than whatever it is, whatever result we come out with as a court. So I will leave the parties with that thought. You've both done an excellent job, and online.
We are live and on the record.
Thank you very much. We are here for the last case of the day. This is a DCF care and custody case, 2020 P 860. The case is impounded, and we asked the parties to refer to the parties by status, for example, the father, the mother, the child, and so forth. I'm sure you've been through that aspect before. Just one final note, we have read the briefs and the record, so we are familiar both with the facts and the legal arguments, so we would encourage all parties to cut to the chase to the extent possible. And we will hear first from the attorney for the father.
Thank you. Good morning, Your Honors. I'm Charles Levin, representing the father. May it please the court. And father respectfully requests that this court reverse and remand the decisions of the trial court that terminated his parental rights and found him unfit. The decision, Your Honors, is based on two false constructs. The first being that father is a violent person with a violent past, particularly as regards mother. The second, that he didn't engage meaningfully in services to address these alleged problems, particularly with regards to the domestic violence services. So let me address the first construct first. And I want to be clear right off the bat, there was domestic violence in this case. Father acknowledged it. The relationship between mother and father was most certainly problematic. It was not a good relationship, not good for the child. So I want to start with that because we're not trying to make believe that this wasn't an issue at all. The point here, however, is that most of the violence that was alleged by the mother, that the judge was concentrating on and continued to circle around and refocus on in her decision, these were not claims that were found to have merit in the courts. They were either dismissed outright or after a jury trial. There were many police reports of other incidents, as I noted in my brief, that were not corroborated.
Mr. Levin, I understand your argument about that there weren't convictions, there were a lot of dismissals and so forth. I just want to make sure I understand. Do you argue that the judge relied on any inadmissible evidence of criminal history with respect to domestic violence or otherwise? Or are you really saying the judge gave it too much weight?
Your Honor, I'm not arguing admissibility. DCF, I think, made a point of arguing that these were in fact admissible materials. There were some motions in limine that were made and that were not made. I think when it comes when you boil it down, the court did not get it wrong on the basis of considering inadmissible material. My point is simply, maybe it's not so simple, but my point is that the information that the court ended up relying upon, namely these charges that never went anywhere, charges that were never brought, information that for which there was no corroboration. This is not the kind of information even given, and it is a given, that the judge can weigh the evidence as they see fit. This is not the kind of evidence you can terminate a parent's rights over. It's in these cases, we hear over and over again, in adoption of Zoltan, adoption of Rona, the evidence that is required to find a parent unfit and terminate their parental rights. It must be strong, positive, full, clear, decisive. This is the language of Zoltan, of Rona, and progeny. It's repeated over and over and over again in our cases. My point is this evidence before you, before the trial court, was not strong, positive, full, clear, and decisive evidence. We know, again, that there was something going on with the parents. It wasn't a good relationship. There was most certainly some domestic violence, but the domestic violence that we know occurred, for example, the January 31, 2017 incident that precipitated the filing of this case, that in and of itself is not sufficient to terminate my client's parental rights. So if when the trial judge says, for example, my client has this voluminous criminal history, which he mentions at conclusion number 23, well, if the court's talking about charges that stuck, then clearly that's clearly erroneous. If it simply means, however, the number of papers in a stack collected by the various police departments, it's correct, but it's immaterial because, I mean, so what? There's a lot of paper, but it's simply mother's literally bare allegations. And too many times they weren't borne out by anything. They're speculative, but the judge simply took them at face value. And I would note as well that I think the department took them at face value as well in arguing its case, especially, for example, the November 2017 charges, serious charges, which led to my client's temporary incarceration awaiting trial before those charges were ultimately dismissed after a jury trial. Those were very serious charges for which there was absolutely no corroboration. They weren't, they didn't go anywhere in the district court at the trial, and there was no follow-up by any other body that at least is memorialized in our record. So, and yet, the court took that at face value that in fact happened. Now, I will note, interestingly, as an aside, that the court never made specific findings that the various allegations that mother made were in fact true. In other words, she never said as to any of the incident reports that I briefed that I accept mother's representation of what happened and I disregard any contrary claim by the father. That's not there. What's there instead is simply these conclusory findings, for example, at 9 and 16, citing father's pattern of domestic violence and assault prior to the subject child's removal. Or at 23, where she cites father's criminal record, voluminous criminal record that involves a number of charges and cases stemming from allegations of violence. Or 26, citing the long and well-documented history of domestic violence committed against mother. So apparently the court simply accepted all of it at face value without parsing it out in any meaningful manner whatsoever. And this is what I urge upon the panel is the problem in this case.
Can I get to the question of the engagement with services? And I understand your argument about the engagement with domestic violence services. I want to focus on the engagement with mental health services. And in the testimony, the social worker appears to acknowledge that getting mental health services was never actually on the service plan, and that the referral to the father to get mental health services was made perhaps in November or December of 2018, a few months before trial. So to what extent, but the judge treated the failure to engage with mental health services as seemingly one of the significant factors here, along with the domestic violence and the homelessness. Does it matter that it wasn't on the service plan if the defendant was referred to those services and the judge treated it as a significant factor?
Well, I think that that's important. I think that what's really important here is the role of mental health, my client's mental health in this case, is extremely nebulous. You'll notice that of the voluminous number of findings in the trial court's decision, there's only three. Focus was clearly on my client's history of violence, the police reports. And if you take that away, if you strip that to what we know occurred and what is really documented in the record, I don't think there's enough to sustain the court's case. The mental health aspect plays a very secondary role because there's nothing there other than the fact that he had purported diagnoses by his own account.
Okay, so I guess what I'm asking is a little bit different. If we were to decide that the judge's reliance on the mental health factor were erroneous in some way, either because there's no nexus or because it wasn't an assigned task or whatever that reason might be, does that affect the result if we do accept the judge's reasoning and findings regarding domestic violence and inability to provide a stable home?
Well, I think it does, only because in so many of these cases, including this one, the judge simply said, this decision is based on all the evidence. I can't remember the exact language that is always used, but the decision is based on accumulation of all the evidence and not a single piece of it. And so it's impossible to discern just what percentage of the decision was based on her discernment of the mental health issue versus the issue of domestic violence and my client's criminal history.
Although, as I think you yourself said, the mental health discussion was very small in the judge's findings and rulings.
Well, it was, and yet she circled back to his failure to engage in mental health until late in the case in multiple findings. I don't remember exactly how many, I'd have to go and count, but more than 2 or 3, probably 6 or 7. So, did that sway the court one way or the other definitively? I can't say for sure. So I think, again, since we're here on this issue of, actually, I see I only have a minute and 55 seconds left. I want to briefly turn to my final issue, which was the issue of the unfitness finding vis-a-vis the judge's failure to make a finding on reasonable efforts. Let me say, the court's ability to address those reasonable efforts does not depend on my clients having raised a substantive reasonable efforts claim below. And I say that, which is what the department argues. And I say that because in every single case, let me put it this way first. This is statutory. Chapter 119, section 26B, first of all, requires that where a child is adjudged to be unfit and in need of care and protection, the court shall consider the provisions of section 29C, which is the reasonable efforts provision. And that comports with the notion that in every single one of our cases, the termination of parental rights cannot be ordered until the trial court satisfies itself that a parent's unfitness is likely to last into the indefinite future with some near certitude. And how can it do that without addressing reasonable efforts? Because after all, if reasonable efforts weren't made, who's to say, or let's putting it a different way. If reasonable efforts were made, who's to say that the parent wouldn't have made use of them to bring his parenting up to?
Counsel, I understand the argument as an original matter, but hasn't the SJC said this issue is waived unless timely raised? So aren't you in effect asking us to overrule SJC precedent?
I would say not, only because it's one that's statutory. They have to make reasonable efforts determinations below anyway under 11926B. And second, since my time's expired, I would just point you again to the case I appended to my brief, Care and Protection of Dimitri, where it was also argued that the issue was waived under a similar circumstance. And the panel of this court said, no, wait a minute, judge may consider the department's failure to make reasonable efforts when deciding to terminate parental rights. And so we're going to take a look at it.
Okay. Do either of my colleagues have any follow-up questions? Seeing none, thank you very much. We'll hear from the department first. I believe you're back on mute.
My apologies, Your Honor. Thank you for the opportunity to speak. May it please the court. Good afternoon, Justices of the Appeals Court. I'm Stephen Carley, Assistant Attorney General representing Appalachia Department of Children and Families. If there's no particular direction that the court would like me to engage with first, given that we have limited time split between the two counsel for the appellees, I'll address directly the father's claim here today relative to lack of corroboration, that somehow the trial court's decision with respect to domestic violence was based solely on uncorroborated police reports and or bare reading of the defendant's record.
I actually would, since you're splitting your time, would like you to address the issue of the mental health findings and the role they played in the judge's decision. I was particularly curious about the judge's finding. I think it was finding of fact 58 that the father was resistant to mental health treatment. I
Yes, Your Honor.
the record pretty thoroughly, and I couldn't find anything that either that the judge cited or otherwise that supported that.
Yes, Your Honor. So the ancillary to that, or as a predicate to that, if I can just reference the court or refer the court to a particular stage in the proceedings. I realize, Justice Sachs, you had a question relative to the social worker's testimony and whether or not the department had ever actually asked father to seek mental health treatment in the first place. I will point the court to volume 2 of the transcript, page 34, where father testifies that the department did in fact ask him to seek mental health treatment.
I don't think that's disputed, and it happened in November or December of 2018, a couple months before trial.
Yes, and what I'd suggest is that there are a couple of findings in the trial court's order addressing the months leading up to the end of 2018 and the first few months of 2019 leading up to trial, in which the court made findings that father had been given opportunities or was directed to services for substance abuse treatment and evaluations, which he did not follow up on. And the testimony was in the record that evaluations done in those few months prior to trial with father, based on interviews with father by the department, indicated that father was fairly candid in admitting that he had not sought services, he had not completed programs at that time. For example, the Elliott Day program is referenced in the record, and the trial court could rely on father's testimony that he had planned, for example, leading up to the days and weeks before trial to enroll in the Elliott Day program, at which case, being a day program, father.
But he did testify, and the social worker seemed to agree that he was in individual therapy for 2 or 3 months at least. The social worker understood secondhand that he had stopped therapy, but the reason for that or what progress he had made in the meantime wasn't that clear. So let me put the question to you this way. Assume we were to find that there was not enough evidence for the court to rely on failure to seek mental health services as a factor in the termination. Can we treat that as harmless, or
Yes.
would we need to send it back?
Yes, it can be treated as harmless, and the reasons are some things that the court has already hinted at argument today. One, it's very clear from the number of findings, especially as my brother, counsel for father, noted in his argument, the trial court's findings relative to mental health were, one, ancillary to the seeking of services and failure to benefit from services, and two, were in fact very brief and not a focus of the trial court's findings of fact and conclusions of law.
Well, but it is something to push you a little bit that the judge seems to come back to maybe in 6 or 7 different conclusions of law about failure to engage in therapeutic services or domestic violence. The court distinguished between therapy and domestic violence and pointed to failure to engage with both.
Yes, Your Honor. I think it's very clear from the record, especially as it pertains to the court's findings relative to the common purpose batterers program, that the court, with respect to domestic violence services, the court had ample grounds to conclude that, especially with respect to the director's, the evidence presented of what the director had said about his participation, that he had not benefited from those services. I concede that as to mental health, the record is more scant or more less definite in those regards. But I suggest, as I was saying before, that these were ancillary matters. They were not central to the court's findings.
Well,
and
how can we be sure of that? I mean, conclusion of law 6, the court says, in making its determination, this court has considered all of the evidence presented in the aggregate. And in a number of the other conclusions of law, the court refers to the mental health issue as well as domestic violence and the inability to provide a stable household. So how can we untangle it?
Your Honor, I think the court should make a distinction at this stage between consideration of the evidence in the aggregate versus the actual grounds, the stated grounds in the trial court's order for the finding of unfitness. And it's very clear, I think, from the court's findings and conclusions of law that there were multiple independent grounds, specifically what I referenced before: domestic violence, the inability to provide housing, and failure to engage with and benefit from services. If there was, in fact, a less than fully fleshed out finding with respect to mental health services in particular, I think on this record, there's no fair reading of this record that suggests that the trial court was relying that as a dependent condition for its finding of unfitness. I think that's abundantly clear from the record. And I understand the court's concern that the court does not want to be in the position to affirm something where one of the ancillary findings may be questionable. But I think on this record, Your Honor, I'd suggest strongly that the evidence for domestic violence was ample, and the court made specific findings in that regard. There was corroboration of those incidents, if not from criminal trial testimony, then in the form of police reports, where police, for example, on October 22nd, 2017, which led to the November 2017 charges that my brother referenced, there was evidence from the responding Brockton police officer that mother's left eye was swollen, her cheek was swollen, she had pain all over her right side. Those were observations independently made by the police officer on that occasion. Moreover, father admitted multiple times during his testimony that he pushed and shoved mother, that he was going to get through a door if mother was blocking the way one way or the other. I'd suggest that in and of itself was sufficient for corroboration, though all of those were sufficient for corroboration. So it's not a bare finding of untested testimony or untested evidence. And I'd suggest that in combination with the basically uncontested testimony relative to housing, those were independent and sufficient grounds to find unfitness. And I see I'm out of time, so thank you very much to the court.
Just to confirm, my colleagues have no follow-up questions. Okay, thank you. We'll hear from the child's attorney.
Thank you. Good afternoon. May it please the court. My name is Debbie Freitas, and I represent the appellee child. I would like to begin with the questions that the panel has asked of my brothers. First, did the court rely heavily on mental health? And the answer is no. The trial court found that father had grievous shortcomings in at least 4 critical areas in conclusion of Law 33. First, his inability to secure housing that could at least accommodate his daughter. Second, his pattern of diminishing his own responsibility. Third, his history of domestic violence. And fourth, his failure to engage in remedial services. The court found those were sufficiently probative and persuasive to the degree of shortcomings, and that they would last.
Let me just stop you. Number 2, failure to acknowledge his own shortcomings isn't an independent ground, is it? That could only be relevant with shortcomings with regard to not dealing with his domestic violence issues or not dealing with his difficulties in finding housing or so forth. So
yes, Your Honor.
It seems like we need to focus more on the substantive grounds.
Yes, Your Honor. And it's clear that even if mental health did not have adequate support in the record to be an independent finding, there were many other shortcomings in which the court could rely on as the grievous shortcomings that lasted into
could perhaps, yeah. I guess my question is, how do we, as I've asked the other parties, how do we untangle and how can we be sure that if we were to find hypothetically that reliance on mental health was not justified, that the court would have reached the same result anyway?
Yes, Your Honor. In this case, the father testified that his health insurance was shut off every time he went to jail. And he estimated at trial that in the 2 years that the child had been in care, he had health insurance only for 6 to 8 months. When he did have health insurance, the record shows he had been seeing a therapist for the first time about 3 months before trial. And by the 4th day of trial, he had revoked his release for DCF to speak to the therapist. The court did not hinge its findings or conclusions solely on father's mental health, but rather on the list, including domestic violence. Which brings me to my next point. Did the court penalize father for having a criminal record? And the answer there is no. The court did not penalize or punish father for having a criminal record. In the judge's findings of fact, father's criminal record was 1 factor out of 8, including employment, his residence, his mental health, substance use, his aggressive history, his involvement with DCF, visitation, and the child's needs and progress. The criminal record findings themselves occupied 6 out of 98 findings. The trial judge did not misstate the criminal record. Father rather takes issue with including the charges without convictions. However, those behaviors that led to the charging are a pattern, and it resulted in being directly related to this case, to both the mother and the fact that the charges, even without conviction, took father away from my client, the child. And yet he continued that relationship with the mother on and off throughout the case. So the trial judge's adjudication didn't rest solely on the existence of a criminal record, but rather on father's longstanding pattern of poor judgment in repeatedly engaging with mother, despite domestic violence, and his lack of accepting responsibility for those actions, notwithstanding that there was a lack of criminal convictions. And in fact, it's inconsequential that his criminal charges were ultimately dismissed, as the focus of the grievous parental shortcoming here was the inability to sever his relationship with the person who led him to be incarcerated and unavailable to parent the child, not the actual convictions or lack thereof. And then I'd like the opportunity to address the issue of reasonable efforts. And the question is, did the judge make an explicit finding? No, the judge did not make an explicit finding here. However, the findings of fact are detailed and specifically go through all of the efforts that DCF made in this case. The record also amply supports DCF having made reasonable efforts, as the testimony confirmed that father had been provided with a referral for a substance abuse evaluation, for mental health evaluation, sent emails about housing workshop, and offered advice on it, reinstating his health insurance, drafting family action plans, communicating with collaterals that were working with father, and scheduling and supervising parent-child visitation. However, even if DCF has not met its obligations to provide reasonable efforts in this case, the case law is clear. The trial judge must still rule in the child's best interest. And here, the judge did make explicit findings and conclusions regarding the child's best interest. So,
Counsel, I want to return to the mental health issues for a second. We have not resolved what to do with this case, but I think you've heard some concern expressed by us about the reliance on these issues. To the extent we're considering remedies and some sort of remand as a potential, are there particular reasons that you think that would be a bad idea? In other circumstances, there may be a premium on, if you will, speedy termination because a placement might be lost. This does not appear to be one of those. So as we're thinking about our options, I just wanted to give you an opportunity to address that issue.
yes, Your Honor, there is consequences that fall to the child if this court were to remand the case. This child has been in custody since she was 9 days old. The father at trial found himself in no better a position 2 years later at trial than he did when the child was initially removed.
DCF's plan, which the court accepted, was for guardianship, and I think has that been finalized? I mean, she's with the maternal grandparents who would be her guardian. So what would change if there were a remand in terms of the child's status in the meantime?
I see my time is up.
You can answer the question.
Thank you. The guardianship requires finalization to allow the child to move forward with permanency. That was the proposed goal because the child has been placed with family since approximately September of 2017. That status remains in limbo until the child has the permanency of which a final adjudication can provide.
Okay. Seeing no other questions, I want to thank all three of you in terms of both the competence you exhibited and the sensitivity to these difficult topics.